Proceeding application, next week it will be taken. Writ appeal. AIDB matter. I'm the writ appeal. Which year? 2023.
Any date in this matter?
No date, my lord.
You have to inform the other side.
I've informed him, my lord. I'll tell him the date also.
Then file.
I've filed.
RFA
Yes.
RFA matter for admission. The performance suit has been declared against me.
What was the suit about?
The performance.
Was there any interim order in the court below?
No, madam.
And where is the urgency?
Execution petition on 13th.
Is a different. Actually, very well. We'll have it. Just give it to. But we hope no objections there.
No, madam.
No
Notice has
objections?
been ordered, madam, after that.
Objections in the appeal.
No, madam. No.
No objection. Just take it.
13th, madam, is the execution. Madam.
We will see it. What is convenient for us?
Your Lordship, I would like to make a mention.
Is there any other mentioning?
Yes.
Which is that?
Appellant, madam, has died, madam. RFA matter. Appellant has died, madam. LR application I have filed. It is not been listed. 1 month, madam, it is not been listed. LR application. Appellant. Please.
Your Lordship,
Good for recovery, my lord. Executive proceedings have been initiated and order. Date of execution, 23. I think of 23.
What is the date?
2023.
What is the date in this? There is no date.
No, my lord. There's no date.
You have to inform all the parties who are approved.
Yes, my lord. It is, they are already in the Wakala.
You inform about the date if we are giving.
Yes, my lord. Definitely.
What is the date in the execution?
Order is already being passed. They are forcing to execute the order.
Why do you come so late?
But we tried before the vacation to.
When was the order passed?
I think in November end, my lord.
fresh matter, partition to dismiss.
This is a matter, nature of matter.
Partition to
Dated.
appeal, RFA.
The urgency,
Adjust.
what is that?
The respondent are trying to alienate and encumber the property, properties.
Was there any interim order at the court below?
No, court below, there was no interim order.
Where is the urgency?
Suit dismissed. By allowing the application and order 7 rule 11 CPC.
You're so dismissed. But you
Dismissed,
didn't have any-
entire suit dismissed.
You didn't have any interim order.
No interim orders there.
Let's see what is the- Is there any caveat here in this?
No case. Your Lordship, this is against a commercial appeal of 2023, Your Lordship. So we had a OS 787 of 2022, which was decreed in our favor. So we have a claim of 27 crores. So this has been stayed by this honorable court, and that is the urgency, Your Lordship. So, Your Lordship, it is 787 of 2022, Your Lordship. They are 10-1, Your Lordship, if it can. Or 15-1, Your Lordship. 10-1 or 15-1, Your Lordship.
3 months also quite big, huh?
Your Lordship, that is the urgency of this 27 crores, Your Lordship. So hence, Your Lordship, there is an urgency in the fact that the claim was actually worth 27 crores. Sure, Your Lordship. Sure. 15th is fine, Your Lordship.
It's listed, we take it, that appeal is listed on 15.
Yes.
Your
Your Lordship, it is, it's not the appeal here, Your Lordship. The appeal is actually in the commercial appeals forum that I'm talking about, Your Lordship. This is basically a memo for listing, Your Lordship, so that this can be heard, Your Lordship, because there is a stay that is in operation by. Yes. Yes. Yeah. No. Yes. Your Lordship. It is pending. Yes. I will have to check the date, Your Lordship. Yeah. Yes, Your Lordship. I shall do. Yes, Your Lordship. Yes, Your Lordship. Yes. Okay, okay, thank you, Your Lordship.
This is a commercial appeal. Your Lordship has granted an order of stay on the ground that the parties are attempting to settle the matter through mediation. And all the mediation proceedings have failed, we are seeking to vacate the stay order as the trial court matter is listed on Jan 20th.
What is the date in this matter?
Well, there is no.
And what is the issue pending now before the trial court?
My lord, the appeal has been filed challenging the order of the trial court where our application seeking to restrain the appellant from invoking our bank guarantees was allowed.
Is it under 39(1) and 2 or section 9 of arbitration?
My lord, it's a suit, commercial
It
suit.
is a commercial suit. Your application was rejected.
My lord, it was allowed. And the appellant, we are the respondent in this matter.
You have filed, who has filed the appeal?
The appellant matter.
The appellant has filed it. You
Yes.
are not for the appellant?
And for the respondent number 1,
In this here also.
please.
Who is appealing for the appellant?
Just so my lord, we got their acknowledgement, we've informed them as well.
You have informed.
Yes.
Is there any date in that matter? No.
Jan 20th is before the trial court.
My lords, this is the RFA of 2022. I am for respondent to
You should inform the
Date
other
note, the
counsel
date,
about the date
Date,
also.
date.
Let him note it so that he can appear.
Sorry, my lord. Date note not. Date note not.
to inform other route.
Oh, 17. Oh, that's not.
My lord, this is the RFA of 2022. I'm appearing for the appellant compromise decree. My lord, it has been dismissed by the trial court. Now he has filed appeal before his honorable court and he has sought stay of the decreed suit. It has been granted by this honorable court. And my lord, the respondent number 1 is 91-year-old and other respondents are senior citizens, my lord. Hence I am seeking, my lord, there is no date in the month of October, my lord. Because it's covered by judgment of the Honorable Supreme Court.
This kindly. Fresh requisition. Sir.
Let's go by this incident, Mr. Kulkarni.
Lords. Yes, I'm mentioning for adjournment because my partner's mother took a.
Yes, Mr.
Fresh matter for admission, writ
What is
petition,
that?
termination matter, out of the CH-2.
Tribunal dismissed.
Yes,
This is urgency.
termination. Madam.
Just give it, take it, give it. Yes.
I have informed the other side.
And inform,
I have taken the signature also, I will inform.
you inform the date also which we will do.
Once the date is given, I will inform.
This case, I'm referring for respondent. The appellant have challenged the commercial court before the sum amount. They have deposited the 12 lakhs rupees amount before the sum. I have filed an application for release of the 12 lakhs amount.
See the date,
Date was not given,
there is no date.
no date.
Just give it, you have to inform.
I will inform, I will inform.
The date also.
Yes, I will inform.
My lords, the matter pertains to pay parity, my lords. The Honorable CAT had dismissed my OA in the year 2022, my lords. Now, before, on one of the occasions before this honorable court, I had presented an order by the department which extended higher pay to 11 officers of the same cadre, my lords. This honorable court had directed the department to confirm about that particular order and only inform this honorable court, my lords. Please, my lords, that is a matter. There's no date given, my lords. They've taken 6 adjournments already, and they've been stating that they haven't been receiving any in October, my lords, of 2024. Please, my lords, I've shared a copy of this memo with the other side. Please, I will share that as well.
Instruction.
Please, my lords.
Yes.
So it's matter for commercial appeal, my lord. We have challenged the judgment and decree passed in commercial court. That there was counterclaim, that counterclaim was partly allowed, my lord, that our suit dismissed, my lord. In the meantime, they filed execution petition, my lord. In that execution petition, the attachment of mobile warrant issued, my lord. That's why I'm filing memo. Yes, my fresh admission not yet. Yes, my lord, yes, my lord. Order of commercial OS.
Against the attachment order.
Yes, no, my lord. Original suit. Yes, my lord. There also the caveat, they felt caveat also appeared, my lord. Decree 21/1/2023, my lord.
File thereafter.
No, appeal immediately filed, within limitation filed, my lord. But they appeared before this court and for admission, they, yes, my lord. Admission not taken. And execution petition date is there on 7/2, my lord. Yes.
My lord, it's RFM, my lord, it's 2023 matter. It's for admission, my lord. It never came before this honorable court. So I'm filing memo, my lord.
Please, what have you filed?
I'm RFM, my lord.
Objections?
No, my lord.
No objections?
No objection, no objection, my lord.
Any caveat?
No, my lord.
Your lordship, your lordship, we don't have dates, your lordship. That is the reason why I had appeared, your lordship, for the memo Phyllis. Yes, your lordship. No, there is no date, your lordship. So if it can be posted for 10th of, your lordship. Yes, you're the respondent now. If you're the plaintiff in the original suit, your lordship.
Is your status in this court?
Respondent, your lordship. Yes. We will do that, your lordship. We will do that, your lordship.
This is an RFA, my lords. It's a suit for specific performance. The respondents have filed an execution petition, my lords. My lords, I'm requesting for a date tomorrow. Please, my lords. It's an RFA. Please, my lords. It's of the year 2022. My lords, the scheduled property is put up for sale auction.
Is it pending?
Please, my lords.
Is it pending? Are you sure?
Yes, my lords. They filed an execution petition.
So when is the date in execution?
24th, my lords, but today there's a spot auction. I'm requesting for a date for tomorrow, my lord.
Was this date fixed?
My lords, there was,
Was this date fixed, auction date?
not sure, my lords, but the date is for 24th.
My lord, I wanted to make a mention. Serial number 21, my lord, I'm appearing for respondent. Matter was listed yesterday night they called. Lords, the urgency is this. My partner's mother took a heavenly abode this morning, so I have to attend there. 21. Otherwise, I would not have mentioned. My lord, I informed. I'm for the respondent number 6, my lords. Yesterday night, they served me the copy also, but kindly give me 2 days accommodation. Yes.
Fifth of March,
Please. Grateful.
serial number 1, Shri Hegde, V.S. Hegde.
For respondent number 1, this
Sir,
was
for
the
the-
matter which was put.
Lord, this is BBMP matter. They stopped the construction against which the interim order. I am before this honorable court. And this honorable court also granted an interim order of staying that, permitting me to construct further. My lord, my submission is this appeal may be disposed of in terms of the interim order already granted by this honorable court, and also keeping open all my contentions raised in writ appeal before the, because my one of the contention is writ petition itself was not maintainable in view of the judgment passed by this honorable court in this type of matter.
Lords, now, my lords, they are constructing 4th additional floor, my lords, which is not at all sanctioned. Please.
They cannot be a total restraint order from construction.
True, my lords.
That has been clarified by the interim order.
Yes,
Interim order dated 23/5/2024, my lord.
States that in view of order dated
23/5/24 by this honorable court.
Last para of that.
Last.
order.
In accordance with the sanction plan in the license, as well as by compliance with the PNP Act and by legal and law. The appeal is disposed of as the petition is still pending consideration before the learned assembly, that keeping open all the contentions of the appellant. Coming to be heard for the learned assembly that. Mr. Pramod who appears for the.
Including maintainability.
Respondent number one. For respond number one, my lords.
All peace before the learned assembly that the petition is between the said submissions. The appeal is disposed of. As in view of order dated 20. What is the
23
23, 5, 2020.
23/5/24.
So everything.
Much.
Serial number 2, Sheshwat Narayan Reddy.
Sir, in this case, I appeal for the appellant. Office raised such objections. One is regarding valuation slip and filing of second set and clarification why you have filed certain documents. Let there is the respondent 1 and 2 filed a suit for declaration, possession, mandatory injunction. I, being the rival owner, contest the matter. But there is he is putting up construction without obtaining sanction plan in the property in question. Thereby. Was there any order in your favor before the court below? Yes, Miller. He has taken undertaking that he will not put up construction during the pendency of the suit. Yes. Disposal of the suit, Miller. Sure. Yes, Miller. Page 216, Miller. Page 215 and 216. No. 216. Let I have produced extract of website because two 115. Yes, website order, Miller. 215. Parties called out, absent, learned counsel for plaintiff, defendant number 1, 2, 4, 6, 7, defendant 8 are present. Representation for it is noticed that in this case, learned counsel for defendant number 2 has filed advancement application and also an application under Order 39 Rule 1A of CPC, praying for temporary injunction against the plaintiff, restraining him from putting up any sort of construction, altering the nature of the land. Having hearing date itself, hence the advancement application does not serve. The interim application is numbered as IA number 36. The learned counsel for plaintiff, that is respondent, Sri PR advocate, undertakes that the plaintiff will not proceed with the construction till the disposal of the suit. He will file a memo on the next date of hearing with the signature of the plaintiff. I have produced photos, Miller. I produced the photos to show that no, he has not obtained any sanction plan. There is no order in his favor. The order is only with respect to 2 sites. The entire extent is 20 good. There's often occur involved.
For the suit about?
Suit is for declaration, possession, injunction, mandatory injunction.
By you.
No, the plaintiff's filed. I am the rival claimant. I say that this is my property, I purchased earlier to him. Plaintiffs, I am in possession. Earlier also he has filed a suit for bare injunction. Subsequently, after dismissal, he has filed a suit for comprehensive suit, Muller. I have taken up a contention that suit is hit by order 2, rule 2 and res judicata. The trial court, after having held it is hit by res judicata,
Whether others have also filed any appeal?
no, I have no, I am not aware of it.
You have defendant number 2 there.
Yes, Muller. I am the main contesting defendant. The others purchased from me.
You will serve the other side.
Yes,
So they have succeeded before the trial.
yes, I will serve.
Yes, just say that.
In the meanwhile, Lordship may kindly pass an order of status quo.
When did they started construction?
About a month back.
Where are we? We will have it next week, but you will serve them.
No.
Okay? Yes, where is the stay application?
Yes, there are two applications are there. IA1 is for stay the impugn order and judgment. IA2 is for injunction restraining from putting a further construction.
Let's say this basic challenge. Court of in respect of the appeals, there are conflict of the appeals because of the urgency that we respond to the and instruction on the property that we file. The Court of Proceedings we have drawn our attention to how have we filed these documents? This photograph, only by way of memo.
Pardon a minute. Photographs I have filed. 2/1/19. Two zero five, page number 205. 206.
Photographs filed along with
One is for stay the impugn order and judgment. And another injunction restraining them from putting a further construction. 1 and 2 minutes.
Do you want
Next week, minute.
to be able to serve them?
Tomorrow, today itself I will serve.
16?
In time, the objection shall be clear.
Yes, but 16/1,
16-1.
high low.
Serial number 3, Shiv Kumar.
Is a paper, the appellate man. This case a paper applied. Some council submission of produce on the translated copy, my lord. In 1 week time, maybe granted to produce.
Happening for the.
Pertaining to 109, 3, my lord.
17-3.
Yes, my lord. Along with that.
Respond, sole respond, please, man.
Connected.
My lord, what has happened? Some of the appellants are respondents in the sum of the order. My lord, everyone is represented. Please, my lord, in all the appeals, everyone is represented.
Serial number 4.
No, madam.
In the second manner,
Wherever there is an interim order in this batch of appeals shall continue till the.
My lords, serial number 4, my lords. I
I
appear on behalf of the appellant in writ appeal 791 of 2023, my lord.
appear for the appellant in 3983, madam.
My lord, this honorable court, by its order dated 4/11/2024 and 10/12/2024, had directed the appellants in 791 to pay a cost of rupees 10,000. The same has been complied with, and the memo of compliance also has been filed before this honorable court, my lord. We were directed to pay a cost of rupees 10,000 for condonation of delay, my lord. No, my lord. It was we had to pay it to Karnataka State Legal Service Authority. We have paid the same. We have even filed the memo. I believe the memo has not been put up in the file, so I'm producing a copy in the open court as well, my lord. We have complied with the same, my lord. My lord, the condonation of delay application that we had filed in writ appeal number 791 of 23 was subject to the payment of cost. We have made the payment. So I request that the condonation of delay application may kindly be allowed, my lord.
It is allowed, madam, subject to payment of cost.
791 of 2023, my lord.
I don't know, madam.
My lord, I can pass a copy to my learned friend as well.
Yes.
I filed a copy before the honorable court as well, my lord. My lord, I was respondent number 6 before the learned single judge as well as before this honorable court in their appeal, my lord, in 3983. There were a portion of the order is challenged by the appellant by my learned senior friend. I have challenged a portion of the order in my appeal, my lord. Please, please. Please, my lords.
Madam, may I submit?
Yes.
Madam, in first appeal, madam, 3983. Madam, I have sought for the mandamus, madam, only mandamus, to issue kata in favor of the society, madam, appellant. Madam, the respondent number.
My lord, before.
1 minute. Madam, in my appeal.
My lord, before any of these aspects are concerned or contended, my lord, may I make one respectful submission, my lord? My application for condonation of delay might be allowed and a date may be fixed for final hearing, my lord. That's my humble request, my lord.
Is not yet admitted. Madam, in my appeal,
It
madam.
was subject to condonation of delay and I mean, the condonation delay application was allowed by order dated 10/4, my lord. Sorry, 4/11, my lord. If I may request my lords to kindly peruse through the order passed by this honorable court dated 4/11/2024, my lord. There was no order specifically passed, my lord. A date may kindly be fixed, my lord.
15-3.
Little earlier, mad, I have sought for only mandamus, mad, it is already in my appeal, mad, it was already appeal allowed. Mad, it was restored, mad, by,
It was allowed in your favor, you're right. So these are cross appeals against the common law. Yes.
My lord, just one submission, my lord. If I may request for 20th of March, my lord, or first week of March.
February
18th.
at least, mad, in February, mad, because
Just see.
that is why, mad, because it is of 2019, mad.
20th March, sir.
I'm so grateful, my lords.
Little earlier, mad, in February, at least. Because only the mandamus, mad, I have sought for issue of kata. Yes.
Okay. He has also come against that order.
No, not that order, mad.
It is
It is
against that order, my lord. That is,
He's
it
appealing.
is the same order that I've challenged.
Sir, 17-2,
Yes.
serial number 5.
Lords, I appear for the official liquidator, my lords, in bill number 5.
My lord, 17-2 is inconvenient. We've engaged the services of a senior counsel. She will not be in town. If I may request. My lord, if I may request for 13-2, my lord. Earlier date is fine, my lord. That date is inconvenient. If I may please request, my lord. 13-2 is also fine, my lord. I'm grateful.
Serial number 5, Shivani Krishna.
My lords, I appear for the official liquidator, my lords, of the respondent entity, my lords. Your lordships are directed that we file a note of submission, my lords. My lords, I may be permitted to file that today, my lords. It's almost ready. I'm just getting it executed in past 5 minutes.
This is being represented by the.
My lords, your lordships are not audible.
So, my lord, in fact, most of the grounds which the company had taken, my lord, would not be available.
My lords, that is the note that I'm filing, my lords. I'm actually filing an affidavit clarifying the grounds that the official liquidator can take and cannot take. That I will file in the course of today, my lords.
They were asked to.
No, you have filed your submissions.
My lords, that is the affidavit which also contains my submission, my lords, which I'm requesting permission to file today, my lords.
What is he saying? You want to
My lord.
file it today?
Yes, my lord, I am filing it.
But what happened, my lord, is that the company which was represented, and then, my lord, they had taken some defenses. Now, my lord, it has been liquidated and official liquidators now stepped in its place.
No,
So some of the defenses, which he wants to give up some of those defenses. That's why.
No, are you representing the liquidator?
Yes.
I am representing, my lords. I am representing the official liquidator on VC.
You are representing the liquidator now.
That's correct, my lords, please.
Very well. You want to put it on behalf of the liquidator this time?
Please, please, please.
When will you file it?
My lords, today, my lords. It's ready, my lords. It's just
give a
getting.
copy. And you want to find any response to that?
I'll be,
Yes,
I have
Mr.
not seen
Krishna.
it, my lord. I have not seen the.
Yes, will, if
Yeah,
required,
if
you
it
will
is
file it.
required, I'll file it. Yes, my lord.
Dilana counsel for the respondents states that are you filing an affidavit?
Please, my lords, please.
An affidavit, affidavit come legal written submissions during the course of the day. Let the same be filed by giving a copy to Mr. Unni Krishnan, who on consideration shall file a rejoinder within 2 weeks or 3 weeks. Within
2 weeks,
3
my lord.
Within 3 weeks, list on.
One submission. My lord, this one, my lord, the trial, the tribunal records have not come, my lord. It has been summoned, but my lord, I understand that is not.
When were they summoned?
Awaited, my lord.
The records as were directed to be requisitioned are still awaited. To stop the registry to ensure that the records as directed. Which is the order by which we asked for that?
My lord, what had happened, my lord, is that we have preferred an appeal against the order of the tribunal, wherein the matter was remanded back for adjudication, which is not possible in law, my lord. Now, my lord, there's a trial also which is pending for the predicate offences and also PMLA.
So we want to know which is the record which we have.
All those matters before the attachment, etc., my lord, before the appellate tribunal.
Before the appellate
Appellate
tribunal.
tribunal, Delhi, yes, my lord.
But why don't you file it yourself? The complete record where is there before the PAP?
Yes, my lord, I can also do, I'll do
It's
it.
better.
Yes, I'll file it.
Take a copy and file it here.
Yes, my lord, then I'll file along with the receipt, yes.
Just
I'll
Mr.
file.
Unnikrishnan says, just cut that. Mr. Unnikrishnan says, though the record of the tribunal have been requisitioned, he shall file the complete record of the tribunal before the next date of year. Yes, that's better.
A copy in the same manner may be provided,
With
my
a
lord, so that
copy-
we all
with a
rely on
copy
the
to
same
Learner
document.
counsel for the respondent liquidator.
Please.
Okay. Thank you. Next.
My lord, the date may be fixed, my lords.
18-2, sir.
Oh, grateful, my
Number
lords.
6. Number 6.
8 to 10 minutes are, so I'll take fresh steps for them.
Let fresh notice be issued for service on respondent number 8 to 10.
Yes, and 6 and 7 minutes, it has come as unclaimed. So service may be held sufficient. For
Full
them.
stop. It unclaimed. Full stop. The insofar as service on respondent number 6 and 7 is concerned, the same has returned with a postal report as unclaimed. If that be so, service on 6 and 7 shall be deemed to be complete, deemed to have been effected. Returnable date.
20th March. Serial number 7, Shri Prakash.
We'll take fresh steps within 2 weeks, my lord.
Let notice be issued to respondents 2 to
I'm
10.
appearing for respondent number 1 in all the batch of.
2
For
to
rest,
10.
I will take steps.
2 to 10,
Please.
returnable on,
20th March.
in all the appeals.
Please.
Obligation.
Serial number 8.
For the appellant, my lords. Steps for taking my loss on the last day.
Let me fresh notice be issued for service on respondent, returnable on.
21st March.
Obligation.
Serial number 9, Shri Anil.
Let fresh notice be issued for service on
Appellant, your lordship.
respondent number 1.
Appellant, your lordship. Still
Pardon?
awaiting some. Appellant, your lordship.
You appear for appellant. Yeah, but R1 is, the service on R1 is still incomplete.
Yes, no, your lordship, the deficit has been paid. We're awaiting summons.
The report is awaited. no?
Yeah, report.
Just say this, the report on service to respondent number 1 is still awaited. The registry to give its report on the next date of hearing.
19-2. Serial number 10, Shri Ashok Patil.
I'm for the appellant. My lord, in the last date, your lordship directed to get corrected the cost title in the impugned order. There was a mistake in the cost title of the impugned order. I have filed an application and order is also passed to correcting that correcting the cost title. I have applied for a certified copy of that order.
You file that.
Yes, ma'am.
Because otherwise the service on R1 to R9,
They have already appeared through advocate.
yes. That's right, R1, Mr. Shankar Reddy is appearing.
Yes, R1 to R8. your lordship.
R1 to R8.
Please.
And even R9 is served.
Please.
But you were directed to serve the counsel who represented them.
Yes, ma'am.
That you have done.
No, ma'am. They have already appeared in the case, so I did so.
We don't know why then.
Applying for the respondent sponsor.
Which respondent?
R1 to R8.
You appear for them, no?
Yes, my lordship.
Okay. Just said as so-and-so appears for respondent 1 to 8. There is no appearance for respondent number 9, those served. The learner counsel for the appellant states that he intends to file an order passed by the trial court correcting the
Cost
memo,
title. Cost title of.
correcting the cost title in the impugned judgment decree,
Order, it's order.
in the impugned order. So let the same be filed within 3 weeks, list on.
17-3.
Please.
Serial number 11.
Let
Lords, I
notice-
appear for the appellant, Lords.
Let notice
Lords,
be
I'll take Lords the necessary steps, Lords.
to the respondents returnable on.
Lords, in fact, the respondent number 2, my lords, that is CPF India. Lords, they have also, my lords, preferred a commercial appeal before this honorable court against the same award. I may be, I may be directed to, my lords, to serve the notice on the counsel who is appearing in that appeal, my lords.
But what is the date there?
Date, my lords, is not given, my lords. The commercial appeal number, my lords, 225 of 2022 is their appeal.
No, but tell us one thing, if against the same order.
Against the same award, my lords. And also order.
But then, have you taken notice there?
Yes, my lords, that I have received. I have received the notice from that, of that appeal.
Oh, do you file a memo for that also? We
Please,
will
please,
listen.
please, my lords.
But we will adjourn it to a date so that you can move a memo for the date fixed, which we will be fixing.
Please, my lords, please, my lords.
Yeah.
I'll do the needful. I'll do.
Returnable on, just give a date.
17-3,
Grateful.
serial number 12, Shri Venkatesh.
Lord, I have for the appellant, Lord, I have to raise office objections. The two objections are filed.
Let the office objection be cleared within 4 weeks, re-notify.
24-2, serial number 13, Shrimati Deepa.
Let notice be issued.
Appellant
to
in
the-
this matter, Your Lordship, we have already done the needful. Summons was taken twice and all the trial court advocate also was served on. But they're not filing their wakalat.
You have affected the service.
Yes, Your Lordship. And we have also complied with the office objections also. There's some,
You mean service incomplete?
So we have to pay process.
that was already confirmed by the board branch yesterday that we have paid a fresh notice. I'm ready to take, Your Lordship.
No, but then why fresh notice again?
A reissue of notice. Because we have already served the copy on them, the PF is also paid.
That's
That's
right,
it.
that's right. But then there is a fresh order on 39/2024.
Yes, even for that, we have complied, Your Lordship. That is also complied.
Complied in what sense?
By paying the.
The
PF.
process fee.
Yes, to that extent, it's done.
You have paid today?
They paid, it was already, but there was some confusion with the branch, so we have
See,
again
the
paid it
report,
yesterday.
the report of the registry says you have not deposited the process fee.
A reissue of notice will be done as of today, Your Lordship, and Your Lordship, on 16/7, this court was grateful to pass an order with asking us to deposit 3,60,000. That is the amount of for the interim stay of the execution petition, which is pending before the commercial court. That is also being done. We have filed the memo. The DD is being deposited before the court.
You have deposited
Yes,
it?
3,60,000 is already
If
deposited
it is, if you have deposited here or before the trial court?
before the High Court, Your Lordship, before this.
If you have done it, you have done it.
Yes, Your Lordship, and based on that, we need execution proceeding was to be stayed, so there is a list.
Now,
Yes.
let's see the order by which you were directed to deposit.
Yes, Your Lordship. On 16/7, Your Lordships.
So this is as good as a stay only.
Your Lordships.
This says so, having considered contention, this court is of the view operation of the judgment decree is to be stayed, subject to appellant depositing this amount along with 8% interest within 8 weeks from today before this court.
Yes, Your
You
Lordship.
have deposited,
Yes, Your Lordship.
so it's all right, it is an operation.
But the trial court
You will
wants to
show it to
speaking.
you will show it to the trial court, the order passed and the deposit made.
We have already mentioned that, but because we do not, there is no speaking order from this honorable court. The executive court.
What more speaking order you want?
At
You
least
see
the
the order-
same thing, I have seen.
If you will say so, if the trial court says so that you will not, it is not taking, you will ask the trial court to record it.
Yes, sir.
Then you produce it here.
Yes.
Then we'll take it to logical end. We will not repeat our orders. One order is enough.
Because
Either
there is a
state-
slight delay in compliance of the order, so.
That's the point.
But it was not before 8 weeks, so.
That's the point. Very well. How much is the delay? Where is the application?
For delay of condonation is all, the delay of condonation, for delay of payment is not produced, Your Lordship. We have not produced that.
He granted 8 weeks.
Yes, Your Lordship.
You went beyond 8 weeks.
Yes, Your Lordship.
You'll file an application for condonation.
Not, no, Your Lordship.
You must file it.
Obliged.
Then once we condone, it's as good as it has been deposited within the time stipulated.
Oblige, your-
That's how you have to go.
oblige, oblige,
Then the trial court is right.
oblige. your-
We'll condone it. How much is the delay? Tell us. Huh? Oh, it's more than 1 year, we have been told. No.
No, your lordships. It was, the order was on 16/7/2024. The DD is.
What is the date of deposit? Tell us.
The date was on, 11/11/2024, your lordship.
11/11/24. And what was the date of order?
The order was, on 16/7/2024. your lordship. There was a 8 weeks,
We'll just condone it. And what is the stage before the executing court?
we have appeared before the court, but as of now, they have not given any movables or immovable list for them to attach. So it stays
So
at
it's
that.
still at that stage,
It's still
notice
at that
stage.
stage, yes.
Just see this. What does the trial, executing court said when you showed this order?
Uh,
When was it last listed before the executing court?
9th of December, it was listed, your lordship. It listed tomorrow again.
Where is the deposit in the court?
We have already produced that.
Where is that?
That memo is, okay, there.
The memo says so. Just say this. This no, did you inform the other side about the listing of this petition today?
Your lordship, they are aware of it, but they are not coming before the High Court, but they are representing before the execution
No,
court.
but when you move this memo,
Yes, your lordship. No, we haven't informed the other side on the.
but have they been served on this appeal?
Yes, your lordship, they are already aware of it. They are, they're very well aware of it. The same thing is produced before this honorable court.
When did they inform it? Where is the memo?
We have served them personally on the trial court advocate.
This is court. How is it listed today? No.
And yesterday we moved, day before yesterday, we had moved the memo, your lordship. Yes, your lordship.
Here, ma'am.
Yes, your lordship.
This appeal is listed. Tomorrow before the executing court. Okay, it shall be that the counsel for the appellant shall not be counsel appearing for the response before the executing court or the listing of the appellant to the counsel and this court is hearing the matter. Please give a date next week.
17. 17.
Execution is before the executing court tomorrow. The request shall be made by the counsel for the appellant for an adjournment beyond the date fixed by this court in this plea, and the executing court shall adjourn the same. Okay, we will ask for his appearance before this court next week.
Yes, your lordship.
Just inform the court.
Yes, your lordship.
File a memo or so, whatever we have passed today.
Obliged.
If they adjourn it, we want to hear the other side, then we will ask.
Obliged.
14, bill number 14.
Yes.
Take a week's time to supply the, my lord. Thing is that there is an allegation against the other respondents also, who have filed a petition before the honorable, before the single judge. For a moment, you will also turn to the impugned order possibly. Of course, as of now, I am not pressing this particular order. On the contrary, because there is an allegation, even the photographs also establishes that they have also. No, only because there is an allegation regarding the respondent. 6 to 7, 6, 5 to 6 to 6 and 7. They are the neighbor. They have also encroached and they have also built their wall.
They have done it. We will proceed. We will proceed. Now, what remains in this?
That is now the IA is filed for that purpose only.
They say there is no violation insofar as the property of respondent is concerned. There are certain violations. And you have to give provisional order of this.
But on the, my lord, the proper survey has not taken place now. That is the main reason. That is the main reason I have produced the photographs for turn to the photograph. That's why I to serve the copies to the other side. I'm for the appellant. Yes. 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 Against me, that only order, the impugned order came to pass. Yes, definitely, my lord. I'm not disputing, my lord. Yes, that has been challenged. Even I have filed an application. No, for a moment, just a moment. I have filed an application before the honorable single judge seeking to permit me to remove my portion of the which was the as found in the survey report. In view of this, I have been permitted to remove that voluntarily. That has been done, my lord. Now the question is because, my lord, because they have also violated. They have not responded to others.
If they have violated, you will proceed accordingly if you want. The petition has been filed by whom?
Yeah, filed by the respondent.
How can it be?
The same contents are also taken before the honorable single judge. The same contents are also taken before the honorable single judge. The honorable single judge did not consider all those things only on the request. I'm not. I do because now before this honorable court.
This is a limited appeal, scope of limited appeal. You say you have removed the whatever is the unauthorized part of the construction, you have removed it.
Yes, I remember.
Then what remains in the appeal?
Because my allegation is that they have not properly.
If you have any grievance, we say nothing.
If possible, you will not reserve the liberty, my lord.
Goes without saying.
Because the IA is there, my lord, for consider regarding that that aspect. Your lordship can give a reserve a liberty so that I can file a complaint before the competent authority. Please, my lord. Because my lord, because in the IA, my particular IA, I made a certain allegation. Certain allegation is made, even though I produced the photograph in prove that.
It's an independent cause.
No, in the earlier petition, I have taken a contention. But even for a moment, your lordship can peruse even the writ petition contention also. Even in the objection also, we have taken the same contention.
BBMP, my lords, respondent 1 to 5.
You have anything, you will proceed.
It's that liberty, my lord.
Don't require any liberty. Tell us something. Did we give liberty to the other petitioner that he approached this court? He made a complaint against you?
Yes, that is, I'm not disputing, my lord. Even he has filed a writ petition. That writ petition, that is the like injunction order the honorable single judge. Yeah, definitely.
That's the locus.
Yes, my lord. In order to appreciate the contention in the IA, my lord, my sincere request is only that much of them. If possible, your lordship can.
This and your own saying that whatever is the unauthorized construction, you have removed it.
Yeah, yes.
So your grievance for the learner single judge doesn't survive.
Yeah.
We are in appellate jurisdiction.
Yes.
Okay.
Yes.
You have any grievance for the construction made by the neighbor who was the petitioner? Proceed. We can say only this.
Yes. That much, that observation can be done, my lord. That observation can be made. Yes. ma'am.
We can record it, that you want to withdraw this appeal.
Yes.
Huh?
Yeah, yeah.
And to seek such remedy as available in law.
Yes, with liberty, yes, that can be, that can be.
Even appearing for the original petitioner.
Now, earlier they have appeared, but today they are not. They have appeared, man. That is the main reason, the objection also, office objection. I have not furnished the copies of the photograph. That is the main objection. Office objection is same on. Only I served to the BBMP.
So here, sir. Yes.
So we will only say this, we will record your submission.
Yes.
If you want to withdraw this appeal and seek such remedy as available in law.
Yes, that can be.
Against any grievance. if you
Yes,
have.
again, the other response, yes, ma'am, that can be. 6 and 7.
Now, all these three petitioners are your neighbors?
Yeah,
All are immediate neighbors?
yes, yes. They are,
Are you saying that?
they are related, my lord.
Saying everyone has.
No, I mean, owner of that particular property.
Who is the owner of that property?
I think,
Tikamani. Or who?
Sudara. Exactly, I don't know, sir. I don't know.
So they are not your neighbors?
No, they are neighbors, but exactly who is the owner, I don't know. That I am sure. I'm sure. I cannot submit that somebody's name, but I don't know who is the exact real owner. But they have jointly filed this petition. IA is there, but that is there. IA too, my lord.
Your IA against their unauthorized.
Yes, my lord. Yes, my lord. I have, it is there, my lord. IA, it was filed. May I give the IA, my lord? Copy. IA number exactly I don't know, my lord. But in fact, subsequently, yeah, the same IA is listed, my lord. That is the even photographs also there. Same IA. Along with the photographs, I filed IA, my lord. 29/8/2024.
You approach the local authority against their.
Meanwhile, there was a writ petition, but I didn't approach. No.
They have made a complete construction.
They did it. They already constructed everything, even they have blocked the photographs clearly establishes, my lord. Entire air and lights have been blocked to my resident. Photograph may kindly take note, take a note. The compound is up to unlimited. $68.
That though the appellant has no grievance insofar as the impugned order is concerned as of today.
Yes, sir.
But as he has filed an application being IA number 4 of 24, wherein he has also stated that that respondents 6 to 7. He has also stated that DB authorities have not taken measurement of the building belonging to respondent 6 to 8. As they have also violated the sanction plan and constructed the building. Constructed the sanction plan, they say violated the sanction plan without leaving the setback. And as such, he intends to withdraw the appeal to seek such remedy as available to the appellants to the local authorities.
Much.
Dismiss as withdrawn.
Much. Okay.
Serial number 15. 15.
I had filed a memo seeking dispensation of notice on the R2. R2 is National Dairy. This party, please, this dairy was unrepresented before the trial court. They have remained ex parte, and the contesting parties are appellant and respondent numbers 1. Please.
Maybe
2 weeks. Lordship, here I have deposited the decretal amount with cost as on 12/12/24. This amount may be deposited in an interest-bearing account until final adjudication of the appeal. Current with the order is the decree passed by the commercial court. Or decree is for 12 crore, 12 lakhs, 33,663. 1 day to lordship. Oh, no, it is not automatic. It's not automatic. A separate order has to be passed. Deposit on 12/12, 16/12. Please.
That in terms of the other part that is put on 12/3/663 before the registrar general of this court, and the same be directed to be invested in an interest-bearing FDR. Yes. Till further orders. And the amount has been invested in an interest-bearing FDR. The registry shall invest the same interest-bearing FDR with regard to the invoice till further orders.
March.
Next.
Lordship, the trial court records also have to be, on last occasion, this honorable court had passed, made an order that the trial court records have to be put in the cause list. It is not reflected about the trial court record.
Serial number 16, Prakash Shetty. 16. Eleven three. Serial number 17, Shri Madhusudan.
Here for the appellant.
12-3. Serial number 18.
My lord, I appear for first respondent in serial number 18 and 19, my lord. May I request for a week's accommodation, my lord? It is ready.
Please, my lord, I appear for the appellant. My lord, they appear for the respondent number 2, my lord, please. Respondent number 1 is state.
I'm sorry, my lord. I'm sorry, my lord. I appear for respondent number 2. I may be granted a week's accommodation, my lord.
Please, my lord. Please, my lord, my lord, in fact, if my lord sees a reference, there is, the way in which it is framed is perhaps not proper, my lord. But what was required to be done, my respectful submission is that it had to be referred to determine whether there was a strike or a lockout. Please, my
lord,
lord.
I will make my
left-
submission, my lord. There are subsequent developments. I will make my submission, my lord.
Just 1 minute, please. See, if ultimately the council says the reference was not happily worded, it need to be worded.
My lord,
so that at least
because all the records are one submission, my lord, all the records are not placed. Factory was closed. Factory government has granted permission under section 25O.
Yes, 1
where
minute,
it is
Mr.
stated
Prabhakar.
it is because of
Yes,
continuous
1
strike.
minute,
my lord.
please. He will repeat her submission and then you make your submission. Now repeat your
Very well,
submission.
sir.
Please, my lord. My lord, the reference that was challenged, it has not been worded appropriately. Whether there was a strike or whether there was a lockout, that is something that was required to be determined by the industrial tribunal, my lord. What the reference says, in one place it says there was a strike, in one place they says there was a lockout.
So that's right.
Please,
Now,
my
have
lord.
you heard her? Have you heard?
Yes,
the
sir. Yes, my
counsel?
lord. Yes, my lord. My lord, this honorable court has already held that there was only a strike, there was no lockout. Permission was granted to close the factory because of continuous labor unrest and threat. And factory was closed in the year 2013 itself. This honorable court confirmed the closure also. Now that the closure also, it has reached finality. I will have to place all the records, my lord, to no adjudication is required because
Very
of
well.
subsequent developments. That will be my submissions, my lord. I may be granted some time to place record because they are not placed the entire records, entire
Is it-
litigation papers, my lord.
Is it
I
your
will.
case? Is it your case? It is not a case of strike or lockout?
It is a case of strike only. That has already been decided by this honorable court. Therefore, my respectful
Very well.
submission to your lordship, no adjudication is required. That material is required to be placed. If I am given an opportunity, my lord, I will come and place all the records
will-
and convince
Oh.
your
May I
lordship
make one
that
submission? May I just make,
Starlight, let him.
I will place on record. But today I have some.
may I make only one
inconvenience, my lord.
submission, my lord? My lords may grant a week's time. Only one submission if I may make. My lord, the reference, if my lord sees that, what it says, my lord, it has 2 points of reference. In one, it says whether the strike from 21/8/2011 is justified. The second point of reference is whether the lockout from 21/8/2011 is justified.
It's not happily worded, let's be
Please,
clear.
my lord, it is not happily worded. My lord, but what has happened is that the learned single judge has set aside the reference in entirety. In fact, my lord, there were two writ petitions filed. One writ petition was filed by the management, one writ petition filed by the union. Even in the writ petition filed by the management, one of the prayers that they have said is that an appropriate reference may be made. Yes, it is a fact that the factory has closed. There was an order of closure.
So the question is only this. Possibly you agree, possibly he also said that's the stand also. There should be an appropriate reference.
Please.
See, it can't be a situation where a party is remediless.
Precisely,
It
my lord.
can't
That's
be
all
such
my
a
submission
situation.
is.
So there has to be a remedy.
Please.
Remedy is by way of an industrial dispute. Industrial dispute means there should be a reference. In what manner the reference must be made.
That's all, my lord. And finally, my lord, even though
I
the
may be
factory, there may be
granted
there may be a
request
closure of the
Just 1
factory.
minute. Yes, at
I
the
request
of
your
the-
lordship to grant me a
Respondent
week's
number
accommodation, my
to
lord.
re-notify on. Just give a date, ma'am. Give a date in February.
Please,
14 to
Next,
grateful.
Much obliged, miss.
both.
20, till number 20. Shimali Patil.
In 20,
Yes,
I
ma'am.
appear for
The
the
office
respondent.
objections, It's along with council submission, my lords, the respondent government councils, my lords, they have not filed the objections in the writ petition, my lords. With regard to that, I made the submission, my lords. Office objections.
No, but the trial court has, the single judge has recorded it.
No, my lords.
Yes. Let's see, 1 minute, 1 minute.
In fact, my lords, the
Okay,
page.
just 1 minute.
Photo number 7. Sorry.
The relevant portion of the order is at page number 34, your lord. My writ-
I tell it that.
No, this is. Huh. Now, what is wrong in this order?
My lords, what has happened, my lords, paragraph number 2 is relevant, my lords. I may be permitted to read that order, my lords. Today, by way of memo, the learned counsel for the petitioner in WP number so and so has placed on record the judgment rendered by the coordinate bench of this court in WP number so and so, my lords. The matter is with regard to the Harvard bench, my lords. Subsequently, on that order, writ appeal was filed, my lords, by the respondents. Writ appeal, my lords, was allowed, my lords. Now the private petitioners, my lords, have approached the Supreme Court, my lords. Now the matter is pending before the Supreme Court, your lordship.
In these matters, writ petition 100726
Please, my lords.
and 725,
Coordinate,
this decided by the Harvard bench.
please, my lords.
The matter went to the Supreme Court,
Please, my
or
lords.
first went to division bench and then to Supreme Court.
Please, my lords. Writ appeal was allowed, my lords. By
Writ
the
appeal by, okay.
My lord, the matter is coming up on 28th of January, my lord, before the Supreme Court.
Then we'll adjourn this.
Yes.
It's only on an interpretation of bylaw 20, huh?
Yes, my lord.
And
Our,
regulation.
our grievance is that no notice was issued before this amendment was made to the bylaws. So we had challenged this clause 20. The learned single judge was pleased to allow our writ petition.
You appear for whom?
I appear for respondent number 11 in this matter, my lord. I'm on KVA.
Okay. Very well. At the joint request of counsel for the parties to await the appeal pending before the Supreme Court arising from writ petition 100726/24 read with the 100725 of 24.
Yes.
Please.
Yes. Arising from the order in appeal. Just say that order in appeal in writ petition number 100726 and 1007. Re-notify all.
25th March,
Next.
Great.
21 adjourned, 22 Kumar MN.
Just see this one.
Let's just remember 22.
Was this thing?
This is a case where
Just say that issue notice.
Notice was
This was issued?
issued, my lords. May I make submission notice briefly? Respond number. Respond one, cause this shows that it has been unclaimed.
Yes.
Apart from that, my lords, issue is not between actually respond number one. It's a matter where the land acquisition officer has to
Where the
clarify.
postal observation. Unclaimed.
That's it. The issue is that for the establishment of warfare, electronic warfare range for DRDO, government acquired the land given to me around 700 acres and odd. The issue is when we have deposited the entire amount, whatever is demanded by the land acquisition officer. The one of the respondent number one filed a writ petition saying that my land has been included in the land which has been acquired and given to me. His name was not shown, my lords. The government, this Honorable Court, Leonard Singhal, in the year 2009, directed the authorities to conduct an inquiry and submit a report. The land acquisition, what he does not identify. He simply says that the respondent shows the land he was in possession so and so where. Like that, he makes one sketch and send it. Based on that, the Leonard Singhal directed us to go for acquisition under the 2013 Act. Actually, whatever the land we have acquired, already we have paid the deposit amount. This is a problem with the land acquisition officer. He has to clarify. He has prepared the joint measurement. He has prepared the sketch. He knows whom and all he has paid the compensation. And this contains a portion of the government land as well as land from the private parties. Some parties say the grant was granted, but government says that they have cancelled their grant itself. This is an issue purely with the land acquisition officer and the government, not with the respondent number one, basically, manners. If they clarify with the proper sketch, there are 2-3 petitions in this fashion, claiming and seeking direction, and they say that my land has been included in that land which has been already acquired and we have compounded. It is the acquisition of the year 1991, manners. The only land acquisition officer can clarify with the sketch what has been prepared while preparing and what has been handed over. That with that it can be issue can be resolved. Otherwise,
Which land is the survey number?
Is survey number 212 months. There are many survey numbers, as far as E is concerned, 112 and 113.
I need to seek instructions in this matter.
This, my respectful submission. In one of the matters, in the very same issue is concerned, land acquisition officer was directed to be present in the court. He did not come. Such an extent he made. He is the one who is causing the problem here, manners. Because land which has been acquired, he has surveyed, he has got a survey sketch, and extent of land handed over is also available with him. He is not producing those records, and he is the one who has paid the.
Now, how would you identify this land? His land?
That is, they have to survey and identify. I am only a beneficiary. Whatever.
What we are saying is, what is the details of that land which have been acquired insofar this gentleman is concerned?
No, there is no record to show that his land has been acquired. They conducted a joint survey before issuance of 6-1 notification in the year 1991. They found that he is not in possession, and he had claimed that he was granted that land. That government correspondence shows that the grant was cancelled because they did not cultivate or something like that, and a large extent of government land is also formed part of the land given to me. This is the government who has to decide and give it us. And according to us, whatever the land acquired, notified, and we have deposited the amount, such extent of land has been handed over, we have compounded.
You are the beneficiary.
I am the beneficiary. Now,
have you filed any objection before the learners? Have they filed any objection before?
They have filed, manners.
Yes.
Where is the objection? Why do we look at, we will see the objection, what objections they have filed.
Yes, please.
But my lord, I seek a week's time, my lord, for proper instructions. Whether a survey
let's
was
see your
conducted.
The correspondence, my lord, kindly see page number 69.
Mr. Kumar, where is the objection? We will see the objections.
Yes.
Na?
Yes, ma'am.
You have not filed it.
They have not filed. I think
You have not filed it in appeal. What they have filed?
In page 74.
74.
Now, 74 is filed by the respondent number 3 and 4, that is appellant. It's not filed.
This is, you have filed it.
Yeah, I have filed, not the statement. I have filed a memos to that effect that they have not filed this.
How do we know that they have also filed the
They
objections?
have not filed, I have filed
They
a
have not
memo,
filed.
page number
It
86.
is not forthcoming in the order of the learned.
Then why don't you
secretary.
file objections?
Yes, ma'am, I will.
You will file it?
Please, ma'am.
The learner, there is no appearance for just say that. The service report on service report in respect of notice to respondent number 1 states unclaimed. Stop, if that be so, comma, the notice on respondent number 1 deemed to have been effected, full stop. The learner counsel appearing for which respondents, ma'am?
2 to 4.
2, 3, 4 states
3 and
that an objections to the appeal shall be filed within 6 weeks from today. Rejoinder be filed within 2 weeks thereafter. Re-notify on. Just take this one.
6-3.
Obliged.
Government advocate.
Just re-notify, ma'am, this matter.
There are certain objections,
19-3.
or we will,
You know, I will,
19-3.
please.
Serial
I will
number
just re-notify.
24.
That's it. 24 onwards.
24 to 48.
I have,
48.
in respect of 24, notice was ordered, my lords, it has been served, nobody has come.
What about the others?
Lords, 24, 28, 29, 38, and 74. Notice was served. Insofar as the others, notice has not been ordered.
Or not ordered?
Not ordered. It came before the court on various.
But it arises from the same common order.
Yes, ma'am.
Just check up that, ma'am.
It has not been ordered.
But what is your ground for appeal?
Lords, my limited ground is the DC had quantified what is the compensation in respect of the land corridor. I have paid the compensation. Despite that, they go before the district judge and they ask for compensation for the land area. Diminishing value.
That means
the land under the corridor, line corridor.
they are unable to use it.
They are unable to use it. I have paid compensation. I paid full compensation in respect of that.
Including that.
Including that, I paid crop compensation, I paid
So
line
on
corridor.
what basis you have paid the compensation?
On the basis of
Compensation,
the order of the deputy commissioner.
no compensation, see, it is not an acquired land in that sense.
It's not an acquired, only right to use.
Right to use.
Yes,
But they say, look here, that right has been taken away,
taken. Okay.
so I have suffered.
Yes,
And that's right. If that right to use has been taken away,
yes,
that compensation is on that account?
yes. Because in respect of various lines, lots, if it is a 440, it is 21 meters. If it is a 740, it goes up to 46 meters. So therefore, we pay compensation based
To
on that.
appear for whom?
I am appear for the landowner, Mr. Respondent.
In
my
which
lord,
matter?
As per this, my lord, the learned single judge order, my lord.
You appear in all the matters?
Some of the matters I am appeared, my lord.
No, there is notice to others have to say. Very well. Now, what was your case?
My submission is, my lord, on the basis of the learned single judge order, they are already satisfied in almost all the cases, my lord, before the court below. They deposited the compensation.
Positive?
Yes, deposited.
In execution?
No, my lords.
Huh.
They voluntarily went and deposited the compensation.
But has it been released
Yes, my lord, released.
to all the landowners?
Yes, my lords.
Certainly it appears, my lords, because I have been making.
Appeal is not
mention
made.
before the-
See, it's be very
Lords,
clear.
but let's, let me just make this. There are some around about 1,000 and odd cases which are pending. And most of the cases, they're showing this particular order and saying that now you pay compensation.
Then why do you implement it?
Sorry, my lords.
Why do you implement it?
No, my lords, I only deposited the amount.
We don't know. That's a
My lords, I will
specific,
take instructions, my lords, in the
Do that.
meantime as to whether it has,
and you have deposited on what, on the directions of which court? There
it's
was
based
not
on the single judge's order that they're entitled. Because I had challenged it, the district judge's order, I had challenged it.
You're right, but why? Were you required to deposit in the court?
They had filed execution.
You have filed an, huh?
They had filed execution.
That she is denying that. That's a specific query.
No, they filed execution. I have the list.
They have filed execution petition.
No,
I have the
but the
list.
miscellaneous,
They have.
earlier we are filed execution.
But
right?
then if it is an execution petition not released, I don't think that really would be relevant.
My instruction is, my lords, all the landowners, my lords, withdraw the compensation. The compensation is very less, my lords, 20, 30,000, 40,000 amount. They already withdrawn, my lords. The appeal is not maintainable.
Just say this, notice, just say that notice in number, which number, 24?
Well, it's from 30,
26.
25, 26, 27, 32.
No, we want notice has been issued in which appeals?
Well, it has been issued in
24, 28, 29, 38, 74.
Just once again,
24, 28, 29, 38, 74.
have been issued in these appeals. Notice, insofar as the other appeals are concerned, has not been issued. At this stage, the counsel appearing for which appellant, which respondent? In appeal number so and so.
For respondent.
In all respondents.
Only one respondent.
All
Only one
respondent or the landowner, yes.
No, you have instructions in which appeal?
So I am received the wakalat filed only in serial number 24, my lords.
24. In appeal number 78-24 states that the order of the learned single judge has been implemented in as much as the amount deposited by the appellant before the court concerned has been released to the respondent landowner in appeal, writ appeal number 782 of 2024. The learned counsel for the appellant states that he shall take instructions in that regard. Okay. And you have to take instruction whether this is common with regard to all the appeals.
Yes, common. I have deposited it in all the.
Check up that, check up that.
I'll
We'll
check up.
notify
Yes,
her.
but still, my
Yes,
lords, I would only say, my lords, let this issue be resolved because everything arises under the same order of the collector.
See, we'll tell you, we'll put it to you. Why should we decide that issue? Why can't we take it? It is your interpretation also.
No, my lords, the
What has
order is
been,
clear.
1 minute. And why did you pay the benefit to them?
So otherwise, warrants are issued, my lords.
See, that's no reason you should have come here and
My lords, the matter was listed, my lords. The
Various
orders
states.
will be various states. It didn't reach, my lords. I couldn't help it.
just a matter of an application for stay. That's all.
My lords, I've already filed it. I can't tell.
We can take it. This is your interpretation also. Maybe you thought that the amount is only what he's saying around 25.
I'm not on the
May I make one
quantum.
submission?
I'm not on the quantum.
May I make
I'm
one
on the principle, my lords, as to whether a person would be entitled twice to the same compensation. That's the principle which I.
You are right. You are actually right. The fact remains that what you have done.
Before filing the appeal, they deposited the amount. Before filing the writ appeal.
What we are concerned is, see, deposit is one, release is another aspect. Release means they have released it to you.
Yes, ma'am.
You are sure? We have recorded your statement.
Yes, I'm with order sheet, my lord. Trial court.
Check up.
I'll just check up.
Then we can possibly, then we will leave the question of law open, possibly. Insofar these appeals are concerned.
Lords, my only concern is, my lords, if this order is being used in all the matters.
Understanding, we leave the question of
Question of
law
law,
open.
okay.
That will help you.
Yes,
Next, just give it in February, ma'am.
short date, my lords.
19,
Next,
they're up to 48.
up to 48.
Next,
49.
Lord, 74 also, my lords.
Yeah, 74 also, ma'am. 74 also is a connected matter.
Lords, in the meantime, lords, if notice can go, my lords, everything could be disposed of.
See, why should we have the authorization? You will deposit process fee, everything.
No, no,
You can save on that at least.
very well, at least that.
Next,
49.
yes, Mr. Rajgopal.
On 14th number, my lords directed the parties to file their.
Now let's see what is
submissions
the
and
issue.
judgments. And the issue is this, my lord, there is some lapse on my part. Written submissions are ready but not filed yet.
We'll see that. Let's see.
Yes, the issue is this, my lord. The appellant is one of the partners of a firm. respondents are partners of the same firm. The partnership deed envisages payment of remuneration to the partners, irrespective whether the firm is under profit or loss. Then, my lords, the respondents raised a dispute against the appellant, who is also one amongst the partners, saying that he is liable to pay the remuneration and other arbitrator. My lords, before the arbitrator, three contentions were raised. One is liability is of the firm, and it is in fact a dispute between the firm and its partners, which is beyond the scope of arbitration clause. Second is, firm is not arrayed as a party in the proceedings.
What would be the status of a firm constituted by the partners only? The other partners were there.
Partners were there, but claim was against the partner. Claim was not against the firm.
All right, but doesn't make any difference, Mr. Raj.
Second is what the finding recorded is that it is not a partnership firm, it is a proprietorship firm, and it is a rent agreement.
Who said that?
That is under section 34.
No, that is your case.
No, that is not my case.
Whose
That
case?
is the finding recorded by the court.
Oh, that's a finding recorded by the.
Finding recorded by the court.
But in any case,
Yes,
if such a finding is there,
yes, ma'am.
then does he say so there was areas of rent?
He doesn't say so. What is it? There is arrears of remuneration.
Acha, he said
And
that-
because, and my lords, under that deed, all are managing partners. Where this says, except the receiving remuneration which is in the form, in the nature of rent.
But where is the finding that this was a rent agreement? These were rental.
That is, my lords, at page 50, that is, my lords, he says, that is, if my lords would kindly take para 20. It is a pseudo part, page 54 of the appeal memorandum. On looking to these clauses, it is very clear that though it is a partnership firm between the claimants and the respondent, it is a pseudo partnership and it is in the nature of proprietorship. Then, my lords, he proceeds to state at para 23.
No, this is proprietorship is it's a one-man show. That's what he wants to say.
He says, my lords, it is a rent agreement also, he says.
Where does he say?
That is, my lords, at para 26, page 59. Respondent show that if the wheel of this partnership firm is lifted, it is only the respondent who is running and all that. Then, my lords, sorry, my lords, I am not able to immediately list. He says it is a rent agreement. In the nature of a rent and somebody has said.
Where does he say?
He says that, in fact, Para 23, my lords, at page 56. On considering different clauses, it is very clear that Exhibit P2 reconstituted firm has come into existence for the namesake and reality. The claimants have handed over their business of running the business to the respondent by agreeing to receive so much and escalation thereon, except they are neither receiving any amount as sharing of profit, nor they are contributing anything to the firm. Entire expenses are 99%. The remuneration mentioned is not depending on the firm. Though it is not clearly mentioned in Exhibit P2 that the respondent have to pay this remuneration. Clause 6.6, which includes.
It doesn't make any difference, Mr. Bangappa. But the fact remains there is a stipulation with regard to payment of remuneration.
Yes, ma'am.
Not by the firm, but by the individual. Now come to para 24.
Yes, ma'am. Who have to pay this remuneration? Though in the usual circumstances, it should be held that partnership sharing would be from the account of the firm. When exhibit specifically provides all expenses are to be borne by the respondent, the same would be the contract between the parties and binding on them. Since remuneration payable to the fixed remuneration, it is in the nature of expenses or not sharing of profit. The expense of firm includes remuneration, whatever be the expenses are incurred in the business and whatever investments that are made all to be responded. Therefore, the respondent is liable to pay the fixed remuneration. Then, my lords,
that's the basis. And the stipulation is by the individual, not by the firm.
Para 26 also he says it is the respondent who is owning.
That's right. It's like this. He is the whole soul in charge. He will call the shots. Everything is being done by him, run by him.
It says all are working partners.
It is there.
Yes, Madam.
But in fact, that's a finding of fact. But what is important is for a claim. For a claim, it would be he who would pay him, not the firm.
For a claim, my lords, he is liable to the firm. He is liable to the firm and not to individual partners.
But that doesn't say so. That's the finding in para 24.
But that is totally misleading of the.
You show us the partnership deed. Whatever is the deed.
My lords, I have filed.
Page 20, it is a pseudo partnership.
That I read.
How much is the liability?
Liability, my lords, is as quantified by the arbitrator at that point of time is 60,40,195. And interest and all, I have.
One is clinic, the others are doctors.
All are doctors.
All are doctors. Maybe he wanted, that's the finding of that. He says that's how he says in a way. That's all.
What he says is, my lords, in effect is the reading of the partnership firm that the arbitration court holds is, it is a rent agreement. Because that is the way it has been read by the. Therefore, my lords, that is a substantial question which has to be.
You show the partnership. We show the partnership deed.
Partnership deed, my lords, I have filed and the documents.
Yes.
Where is the document? Deed of reconstitution is at page 137. I have filed the entire pleadings by a separate memo. Document number 15.
Which page?
Page 137. Class 6.1 at page 140, members.
137.
137, the document commences. At page 140 is class 6.1. Sorry, my lords, I don't know whether paper book they have given a running page number or separate.
We don't find. What does it say? Where is the stipulation for paying the?
Paying remuneration, my lords. The partners agrees that the remuneration shall be paid to the existing partners and the incoming partner, one, on or before the 5th of every month, following the month for which the remuneration relates.
Who will pay it?
Who will pay it is the firm, because it has not been mentioned that I will pay.
Let's see that we. Have you got it? Which is the page?
Page, my lords, I have filed these documents
31st August.
on 31st August 2021. Sixth.
Yes.
At page 141. Clause 6 is management of the firm. That is again repeated at clause 7, page 141.
Okay. Who appears for the other side?
Other side, Madam Kavita Damodar. Mr. Dhananjay Joshi, senior counsel, was a representative.
You say none for the respondents, re-notify.
Two, sir, 24-2. Serial number 50, is Suresh Babu. Serial number 50.
Notice, they say none for the parties, re-notify.
24-3. Fifty-one. Abhinay, 51.
He was there, no, yesterday. Just pass over.
52.
Pass over this also.
53. Serial number 53.
With my lord's kind leave, I pay for the appellant in this case, my lords heard this at length on the previous date, please, my lords. I was to verify certain records, my lords, but I could not find it in my records, my lords. Could I be permitted to go through the original records, my lords, and make my submissions, please, my lords? I pray for short accommodation, my lords, to go through the original records. We couldn't find it in the institute's records as well, my lords. My lords had requested, my lords, whether the subsequent contract had been placed on record, my lords, as a evidence, my lords. So those aspects, my lords, I could not verify from my records, my lords. I pray for short accommodation, please, my lords.
Just wait, pass over. We'll just see.
Please.
Fifty-four, Patin Patna. Neeraj Kumar.
My lord, this is
Have you checked
yesterday's
up, ma'am?
case. Yes, my lord. My lord, my only submission is with regard to the learned single judge's order has been rightly passed. Firstly, with regard to an inter-court appeal would not lie because this is under 482, as I mentioned yesterday. And also with regard, if we look into the paragraphs, my lord, of the learned single judge's order, he has dealt with the issue of jurisdiction also. My lord must have already read it. From para of 48, my lord. And that decision I have with me.
See, at least, in fact, we are going to put it to him also.
Please.
Mr. Chadda, let's assume your appeal is maintainable. Yeah, let's assume. What is your case on merits? Two things. The learner single judge doesn't say that this is filed, the FIR is registered in Panipat. Hence, we have no jurisdiction. Doesn't say so.
Yes, my lord.
He doesn't say so.
Yes, my lord.
He goes on the merits of the allegations, refers to judgments of both in Rupali, or which is that judgment?
Rupali
Rupali
Devi versus Uttar Pradesh.
Rupali Devi
State of
and
Uttar
Arnab Ranjan Goswami.
And come to a conclusion that no interference is called for.
Yes, my lord.
That's right.
Yes, my lord.
What is your take on that?
My lord, here the facts have not been brought correctly. Factual inaccuracies are there. And then since the factual inaccuracies are there, the legal metrics has also been applied incorrectly.
What are the factual inaccuracies?
My lord, first, this Rupali Devi has been applied on the premise.
Forget Rupali Devi. What we are asking you is whatever facts he has noted in your case.
Yes, ma'am.
Have been rightly noted?
No, my lord.
What are those? In fact, come to paragraph 46 onwards.
Para says admittedly the marriage between the petitioner number 1 and respondent number 3 was held at Panchkula, Haryana. Subsequently, the accused number 1 and his family
That's a fact. That is a fact.
Only that much. The latter part of the para, accordingly, she has left Bangalore in 2020 by giving information to the Banglagunte police, and she went to Panipat where her parents are residing. This is incorrect. This is incorrect finding, and where she filed her complaint. She filed her complaint, my lord, after 6 months of the initial FIR being filed in Bangalore.
Initial filed by you.
No, my lord. By her. Filed in
not
Bangalore in Banglagunte police. And according to TT Antony versus State of Kerala, only
where is that complaint? Where is that FIR? That has not been agreed to by the learner single judge. Where is that?
That's what, according to Lalita Kumari, that has to be necessarily considered as.
Mr. Chadda, we have asked you a question. Where is that?
Page 369 and page 371.
Okay.
Starts from 350, my lord.
This is the translation here.
Yeah, page 369 is English.
That's a translation.
Yeah, Annexure G.
Now,
to the station house officer, police station, Banglagunte, Bangalore.
See the last line. I reserve my right to file a detailed complaint in concerned police station of jurisdiction.
My lord, there is no concept of reserving this right. Only the earliest and first information in regard to commission of a cognizable offense satisfies the requirement section 154. Therefore, there cannot be a second FIR and no fresh investigation. Pursuant to this, if full 8 police personnel of Banglagunte police station immediately came to our residential premises, they carried out the full investigation, which led to recording this statement in Canada. She clearly stated that I am leaving this matrimonial house on of my own accord and I am shifting to my bank quarters. At no point of time she stated that I am going to Panipat and staying with my parents. She is a chief manager in a nationalized bank, Punjab and Sindh Bank. By virtue of her duties, she has to necessarily stay at point of her official duties only. There is absolutely no extension of the parental premises here to Bangalore. She has shifted. She is clearly admitting that I am shifting to my bank quarters here in Bangalore itself, in Venkatadri
complex. Similarly, in 164 statement, which she recorded in Panipat, she is clearly stating that I am staying alone in bank quarters with my parents. Kindly have a look at that 164 statement recorded in magistrate.
Did she go to Panipat from here?
No, my lord, at no point of time. After that, she was transferred to Delhi West Patel Nagar branch. After that, she was transferred to Raja Park branch, Jaipur.
Now, where do you say so that she did not go to Panipat?
Pardon?
Where did you say in your petition she did not go to Panipat after leaving Bangalore? She did not leave Bangalore.
Yes, my lord, she did not leave Bangalore. I can even place on record a sufficient auction notice.
Whose statement was recorded?
Pardon?
Her statements.
Her statement has been recorded in Kannada, my lord.
Where is the translation of it?
373. Page number 373.
That's the first information report.
I am residing at the address shown above and working as chief manager in Punjab and Sindh Bank, residing at the house of my husband. I have gone to the address provided by the bank along with car, laptop, clothes, 2 jewelry in my name. There is no quarrel between me and my husband. This happened on 8th August 2020.
Yes.
And this FIR was filed on 16th January in Panipat after 6 months.
When did she leave the place? When did she purported to have left the place?
8th August 2020.
8th
And
August.
complaint she is writing on 6th August, before that only.
And my lord, you see,
No, was it 8th
just want
August
to
or
bring one
was
thing.
it 8th August or a day before, before she, when did she leave?
Sir, he left on the 8th August, but the complaint that he's writing to this.
On 6th
police-
August, she gave the complaint to the police.
Police
Police had-
already taken some
police had
quarters
sufficient
before that only.
time to carry out the
By quarters,
investigation.
He has already planned that.
1 minute at a time, one at a time. Okay, that's the date of complaint. The initial was at 6th August.
Yeah.
Yes, my lord, 6th
This
August.
recording, this statement was of her statement recorded.
Yes, on her own volition, this statement was recorded and she has walked into the police station. But later, my lord, this complaint is being sent from Bangalore through post. Through post, it is sent to Panipat, my lords.
What is 372?
372 is a typed Kannada copy.
But
And
is it-
373 is a translation copy.
No, but this says 3821. Is it 3821 or 8821?
Not 38. Not 88. This statement recording date, statement was recorded on 8th August, 8th August 2020.
But what is this 3821? At page 372?
Page 372. But by mistake, it would have been typed. By mistake, it would have been typed.
It is actually,
In typed copy.
yeah, where?
My lord, if you see the below page 371, where she has signed, she has clearly written the date. It's 8/8/2020.
Just 1 minute. Which we considered is that, we didn't- But you were as a fact married in Panipat?
No, sir. No, my lord.
Which place?
It happened in Panchkula.
Oh, Panchkula. What you said, Panchkula.
No cause of action arose in.
Yes, 1 minute.
Panipat.
Panchkula married. Now just see the single judge order. Six. Marriage which was held at Panchkula. But tell us one thing, man.
Please.
Something, even the learner single judge holds.
Yes.
If you see page 46, para 46. When was she transferred out of Bangalore?
My lord, that is not known. When she transferred and when she was transferred to West Patel Nagar, not known. However, I am having a sufficiency auction notice of the November month that she is posted in West Patel Nagar branch.
November.
Yeah, November. And
Please, my lord.
Now, see, it's like this. Panchkula is different from Panipat.
Please.
And that's the, so there is nothing relatable to Panipat. At least surely being a matrimonial issue.
My lord, that's why the lordship has looked into this judgment, that is Rupali Devi. If your lordship looks into this judgment, I would like to just place it. The reading of the judgment goes into the scope of.
Where is the parental place?
The parental place is Panipat.
Panipat. But my lord,
Panipat.
judgment says
That
three
is why-
conditions. My lord, three conditions are there under that judgment. One is she would have driven out of her house because of the cruelty unleashed. Second, she takes a shelter in her parental home. And third, it will be subject to the specific circumstances of each case. If we look into this statement which she has recorded, we cannot say that the statement is irrelevant. She's clearly telling, I am moving out of matrimonial house out of my own volition and free will, and I'm going to stay in my bank quarters out of my own free will. So both these conditions are not satisfied. And
Not one
she
submission.
has not at any point of time taken shelter in Panipat.
That's what's so part. He says, see this. Husband, relative, husband, wife, please, matrimony, shelter in the parental. A different place. A different place. The court situated in the field of parental wife for the jurisdiction to it. The parental place is Panipat. What she says, she has not left. Till now.
My lord, in M.
So. Issue notice. Criminality laws of industrial. The submission of the notice. Will issue
My lord,
notice.
just,
My lord,
I just want
any
to,
plain lodging FIR leads to embellishments and exaggeration which they create of afterthought.
1 minute, Mr. Chadda. We'll issue notice.
my lord, with regard to notice, my entire argument would be an intercourt appeal is not maintainable
That we'll
because,
see. I think prima facie.
please, my lord.
Number 2, we will issue notice.
Yes, yes,
Let them come.
yes. However, I think it is,
Actually, to be very frank, the state doesn't have any role.
please, we don't have a role,
Yes, yeah.
however, yes.
It's not even your FIR.
It's not my FIR, nothing. I'm just substantiating and
Right, as you're
backing
assisting
the
the court.
order of the learned single judge.
We'll see this. Just say this, though the registry has raised an objection on the maintainability of the writ appeal. As according to the writ appeal, the submission of the appellant who appears in person, one of the appellant who appears in person, is that the FIR being the subject matter of the challenge in the appeal is then FIR registered in Panipat, Haryana, and a court in exercise of jurisdiction under 482, section 482 of the CRPC would not have set aside the said FIR, and the petition having been filed even under Article 226, read with 227 of the Constitution of India, the impugned order of the learned single judge must be read to me an order passed under 226, 227 and not under 482. And as such, an intra-court appeal under section 4 of the Karnataka High Court Act shall be maintainable. Full stop. Leaving the issue of maintainability open, comma, we deem it appropriate to issue notice to the respondent number 2 and 3. Full stop. Full stop. We issue notice, so and so accept notice for 1.
Please.
Let notice be issued to respondent number 2 and 3 through all modes. You have email also?
Yes, my lord.
You serve them through email also. Returnable on, just give it in mid-February.
Interim
My
stay.
lord, just one submission.
What happened? You tell us one thing. Was there any stay during the learner single judge?
Yes, my lord, it will stay all along. Only by CAV order which was.
In this case.
Yes, my lord, in this
The
case only.
repetition.
My lord, I have produced the additional
the
document to
FIs.
substantiate that.
You can
Stay
say the
was
stay
there.
order, sir. It was stay was there.
Where is your stay application?
My lord, I have filed IA for stay. Page number, one moment, my lord.
Just for a moment, if your lordship could just look into Ramakrishna Fauji, which was filed. In that, my lord, at page 61, if you look in,
693, my lord.
Huh? Yes, ma'am.
my lord, in that case, that is Ramakrishna Fauji versus State of Haryana and others, if you look at para 61 for a moment, if your lordship would just look into that
What the
one
judgment?
particular para. This was with regard to the Lokayukta case and to quash the complaint before the Lokayukta. And looking into that aspect, whether the Lokayukta being a quasi judicial body would tantamount to a civil proceedings under 226 was the issue.
No,
Now,
we are not concerned with.
yes, but I just want to
We have
bring it.
noted his submission.
Yes, my lord, just look into that paragraph, para 61 in Ramakrishna Fauji, our
Ma'am,
memo ali
we
hakidru.
have left that question open. We still will look into it.
Because it would just mean that by entertaining and having this maintainable as read under Article 226, it would lead to bringing to naught the criminal jurisprudence, my lord, because the entire object of not having a intra-court appeal where criminal jurisdiction is
Sir,
concerned.
You would agree this,
Yes,
if it was an order under 482, in a petition under 482,
please.
intra-court is not maintainable. You agree there?
Yes,
But the line of judgment which he has referred to,
yes.
though petitions are filed under 226, 227 and 482,
Yes, what is the
Have-
litmus test to be looked into?
right, we are coming to that. In substance, you would see what is the petition about. In substance, you see what is the nature of order passed.
Please,
A nature of order can be not akin to an order under 226, 227,
please,
but an order akin to or in a petition under 482.
please, my lord.
Then the court says, "Look, 482, it's an order under 482, no interference."
So my submission on behalf of the state and the supporting the learned single judge's order is that here the appellant has asked for quashing of the FIR. So when it pertains to quashing of an FIR or complaint, it would come under 482 is my humble submission. And
What is being
therefore,
argued is, that's right, you are right. If it was within the state of Karnataka, there is no dispute, there is no issue. What is
Precisely.
being contended, and that's what we have recorded,
with regard to that
outside the state.
territorial jurisdiction, my lord, the learned single judge has appreciated that also by looking into chapter 13 of the CRPC. Chapter 13 of the CRPC, we were talking about 178 and
Show us,
169.
show us which paragraph.
Starts from my lord, I would like your lordship to look at para 48 for a moment, wherein I have just placed before your lordship the reliance of Rupali Devi. Wherein the scope and ambit of 177, 178.
No. This is not on an import established here.
Just,
See, there can't be any dispute issue.
please.
220, that's what we have saying, the drawing a distinction between 226 order and a 482 order.
Right,
226, 227, intra-court is maintainable.
yes.
What is being said is, now what is the submission is, that this can't be an order under 482. Because under 482, the learner single judge could not have set aside an FIR which is registered beyond the territorial jurisdiction of this court. It
But,
can only be under 226, 227.
Precisely why I have placed this judgment of this coordinate bench, which
Sure.
speaks about when it relates to quashing of an FIR. Anything relating to quashing of an FIR, the section of 482 comes into play.
You're right.
And therefore, the argument addressed by the appellant would not hold any water.
That means to prevent an abuse of process of the court.
Please.
That can be interfered. No, there is no dispute. See, that's what we are telling you, and that's what we have adjourned it for today.
Yes.
You will only show us this.
My lord, just,
Can a court in exercise of 482 set aside or quash a FIR which is beyond the territorial jurisdiction? You know, in a high court in exercise of 482, can it set aside? That's what we want to know.
no, it hasn't set aside the FIR of the, it has dismissed his application.
Suppose.
It has dismissed his application for quashing of that FIR,
Yeah.
saying that the jurisdiction of Haryana to look into it, and that is the perfect jurisdiction based on chapter 13 of the CRPC, which speaks about the local jurisdiction should inquire into matters of criminal, pertaining to criminal jurisdiction, sorry,
My
No,
lord,
but
this
what we are
argument,
saying is you're right.
please.
He has not, but he went on merits and then set aside
Set aside,
and dismissed it. He said no interference with the FIR.
yes,
That's what
why?
he said.
It cannot be interfered with because the local territorial jurisdiction is Haryana, and therefore the appellant's claim to set aside the FIR has been dismissed by the learned single
Is
judge.
that finding?
my lord, this
My lord-
argument goes against them only. Because the entire cause of action has arisen within the territorial jurisdiction of the courts of Bangalore only. And section 177 clearly says every offense shall ordinarily be inquired and tried by a court within whose jurisdiction the offense was committed.
My lord,
Where
if I
is that finding?
if I may just read from para 48 of the learned single judge's order for a moment. In the case of Rupali Devi, he culls out para 5, 6, 7, 8, 9, 10, etc. And they look into the scope of chapter 13.
Ma'am, you are not understanding. This is
Please,
only
please.
to say this.
Yes,
What has been said in Rupali Devi is
yes,
a court where matrimonial is at one place. She has gone to another place,
Yes.
parental home,
yes,
for residing.
yes,
The FIR or the court there can also take cognizance. That's Rupali Devi says so.
yes,
Very
yes.
well.
And
Now,
therefore,
based on this, the learner single judge was of the view that this FIR at Panipat could have been filed.
yes,
That's the basis.
yes, yes, yes. And therefore doesn't go into quashing. The quashing of the FIR, crime number 33 of Haryana, charge sheet of so-and-so punishable under 498A, which is hereby dismissed. He has dismissed it, and rightly so is my humble submission.
Yes.
Because the jurisdiction is with the Haryana court, based on chapter 13 of the CRPC. And he has rightly looked into the FIR filed in Bangalore, saying that it was beyond jurisdiction. The police have gone beyond jurisdiction with regard to the FIR in Bangalore.
Now, where is that finding of the learner single judge?
With regard to Bangalore, my lord?
With regard to beyond the jurisdiction, or it was in Panipat, we will not interfere. Where is that?
Right. Now, if we look into para 49 onwards,
Yes.
the marriage of the petitioner in
with respondent 3 was performed in Haryana near so and so, so and so. The apex court in the case of Rupali, though his matrimonial home at Bangalore, but Haryana police has also the authority to register the FIR and investigate the matter herein, wherein respondent 3 had taken shelter in her parents' house at so and so. Therefore, the offense under 498A IPC, which is a continuous offense, the complaint can also be entertained in Haryana police and they can file the charge sheet. Hence, the contention of the petitioner that the Haryana police do not have any jurisdiction to register the case and file the charge sheet cannot be accepted.
That's right. Now stop here.
Yes,
This is based on Rupali Devi.
yes, please.
So that means she could have filed an FIR in Haryana or they could have registered.
Yes.
They stop. But read 50, we'll come back after lunch.
However,
We'll come back after.
please, much of a small indulgence.
What is that for?
It's a RFA, my lord, filed in the year 2023, my lord. The connected matter has got stay, my lord.
It's all right. We can mention it tomorrow morning.
Your
not
lordship,
now.
a small indulgence.
Yes.
Apologies, your lordship.
May-
Serial number 49 was called out. I was not present. I appear for the respondent. A date has been given in the month of February. Can I request for a date in January? I'll also inform the appellant counsel.
Who appeared, ma'am?
The appellant appeared, your lordship, and secured a date. I was not present when the matter was called out.
Yeah, Mr. Yeah, this is that partnership firm.
Indeed, your lordship, but
We'll have it in February.
May I please, your lordships, list number 1, serial number 50, I'm seeking adjournment. The advocate for respondent is also
Which
here.
number?
List number 1, serial number 50, your lordships.
Appearing for respondent number 1 in this matter.
50.
Yeah, yes, your
Yes, ma'am.
lordship, 50.
We have adjourned it? We have adjourned it.
My lord, serial number 60, my lord.
Come back.
Leave the meeting, leave the meeting.
Court officer. Court officer.
Sir, ಹೇಳಿ sir. Sir, ಹೇಳಿ.
Madam, serial number 25, 4 and the 52 jump ಆದ್ರೆ madam.
Sir, ಅದೆಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್ ಸರ್.
Thank you, madam.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 63 ಅಡ್ಜಾನ್ ಆಗಿದೆಯಾ?
ಇದೆ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
सभी काम करना.
Yes, what do you want? You are there. Who is there other side? Yes, you are for whom? You are appearing for whom? At the request of counsel for the appellant, re-notify. Give a convenient date.
19-3.
Next, yes.
My lord, serial number 54.
You just come back, just hold.
My counsel on record is not feeling well.
He is not?
Counsel on record is not feeling well.
Okay.
Kindly short. 54.
Appellant,
54. Sorry, 55, 55, sorry.
you appear for appellant?
Yes, my.
Respondent person.
Appellant, 55, serial.
In which matter?
55, sir.
Commercial
55.
appeal, 239 of 2000.
At the request of so-and-so, re-notify on. Come, yes. Rishi.
20th March, sir.
Madam,
Yes, ma'am.
My
We
lord,
will,
I have a humble submission to make, my lord. My lord has already ordered that keeping the issue of the maintainability
1
open.
minute, Mr. Chadda, just hold on. We'll keep the, we'll look into it. We are not deciding the issue. See, mind it. If it is maintainable, then we need to look into the order of the learner single judge. It's primarily the prayer which is left is primarily related to or directed against the FIR got registered by the respondent number 2. She need to be heard. Right? So we'll hear her. She was there a party, she was there before the learner single judge?
Yes.
Yes, for 2 months. My only solution
Number 60
notice under an appellate jurisdiction would be a little beyond
Why?
because
Yeah, sorry, we will not take that.
my lord, if your lordship can just.
We have not concluded finally. That's it.
For a moment, bow down to your kind indulgence. Just for a moment, if your lordship can see Ram Krishna 40, the last paragraph, that is para 60, 61.
Shows that.
I'm only on the concept of law. That's about it. Nothing beyond that.
Which judgment you said?
Page number?
It's in the citations forwarded by the
Page number.
page number Nande. I have.
Yes.
Which one?
61, my lord, the last.
195.
I'll just read it, my lord, for a moment. In the case at hand,
Which paragraph you are reading? 61. Yes.
one which starts as in the case at hand. Whether the citation produced is 2017 5 SCP 5. Then I guess there will be a variation.
Paragraph starts.
It starts in the case at hand. The writ petition was filed under 226.
My lord, it is para 65. Para 65, page 215.
That paragraph, my lord, in the case at hand, the writ petition was filed under Article 226 of the Constitution for quashing the recommendation of the Lokayukta. The said recommendation would have led to launching of criminal prosecution, and as the factual matrix reveals, FIR was registered and criminal investigation was initiated. The learned single judge analyzed the report and the ultimate recommendation of the statutory authority and thought it's extremely to quash the same, and after quashing the same, as he found that the FIR had been registered, he annulled it, treating the same as a natural consequence. Thus, the effort of the writ petitioner was to avoid the criminal investigation and the final order of the writ court is quashment of the registration of the FIR and the subsequent investigation. In such a situation, to hold that the learned single judge in exercise of jurisdiction under Article 226 of the Constitution has passed an order in civil proceedings as the order that was challenged was that of a quasi-judicial authority, that is locally would be conceptually fallacious. It is because what matters is the nature of the proceeding, and that is the litmus test. So my lord, my only submission is, by virtue of issuance of notice and entertaining a writ appeal of such a nature.
My lord, can I make a humble submission? If you want me to dismiss it? No, ma'am. Don't interfere like this. Oh. Now, what is the conclusion?
Conclusion is, in view of the aforesaid prismatic reasoning and irresistible conclusion is, please.
Conclusion of the division is that the order was an order under 482 or 226?
482. Yes.
So 482, it could not have been quashed or it could be quashed.
Under 482, it can be quashed because we're talking about quashing of an FIR and a complaint.
Yes.
So that is the entire premise on which the appellant has come before this honorable court. There are two FIRs in this case, my lord. One is, if I may take just, I'm sorry for the indulgence, but I just want to bring it to the light of the. So there is one FIR which is crime number 50. That is the local jurisdiction of Bangalore has initiated. That has been quashed by the learned single judge. The second is the FIR which is at the Panipat police station, Haryana police station, that is crime number 33. Now the learned single judge has not gone into it at all. It has dismissed the contention of the appellant to get into the merits or the authentic.
What you are saying is
Yes.
this. It's not a question of, it did not go into the aspect since the affair is registered outside the territorial.
He hasn't gone.
He hasn't. He
He's
has gone on,
only
he has gone on merits.
Yes.
He looked into the merits of
Under
the allegations.
482.
The 482.
Yes.
And
rightly so.
And rightly said that it cannot be quashed.
Please.
Given the facts.
Yes,
Given
yes.
the-
So it's
So it's an
a
order under
reasoned,
482.
yes, it's a
That's what we
reasoned
said.
order under 482, and there is no thing of extraterritorial or beyond the jurisdiction as canvassed by the appellant. And here it is a case totally under 482 realm of criminal jurisdiction. And there is no need of looking into it under Article 226. There's no inter-court appeal that would lie, is my humble submission.
If it is a 482.
Yes.
Yes,
And
what is,
therefore, I
yes,
would-
ma'am. What is saying, Mr. Kapoor?
My lord, yesterday also I had pleaded, and once again, I again want to. But only under Article 226 to extraterritorial jurisdiction can be exercised. This is the time and again I am telling.
Did not refuse to quash the FIR on the ground that it is beyond his jurisdiction, beyond the territorial limits of this court. He doesn't do that. He examines the factual aspect of the allegations.
But factual can be examined only under 226.
He went into the factual aspect of the allegations and says that in these circumstances, the FIR has been rightly filed there, and it is permissible in law based on the Rupali. And he said that it need not be interfered with. That's his submission. None of the paragraph, at least you have also not pointed out, to say that the learned single judge conclusion is that since it is beyond the territorial limits of the court, he would not like to set, quash the FIR. That's not the finding. what is being contended by you. Okay, you're making the point. What do you have to say?
My lord, it has to be necessarily examined under Article 226(2) only. It cannot be examined within the purview of 482 because 482 does not permit to carry any exercise powers beyond the territorial boundaries.
226.
482, yes or no?
My lord, that is what this nomenclature of the
Voices.
Oh, my lord, kindly, my humble submission. I will argue. My lord, that is what precisely the other day when we were referring to Jarappa's judgment, it was clearly stated that in case the court exercises power under 226 of the Constitution of India in a petition where section 482 of the CRPC is also invoked, then the court would get jurisdiction to entertain the appeal under section 4 of the Karnataka High Court Act. However, despite invoking Article 226 of the Constitution of India, if the court chooses to exercise its power under Section 482 of the CRPC and passes an order in exercise of such power under Section 482 of CRPC, appeal under Section 4 of the Karnataka High Court Act is not maintainable. So it does not met. In our case also, the format in which the petitions are filed in High Court of Karnataka is this only, that read with this. But substantially what matters is under which provision the power has been exercised by the learned advocate. The other day when I was referring to the Chhattisgarh High Court judgment, I had again
Okay, so repeat the question. Where is the protection before the learner single judge in your law?
my lord, page number 593, 693, 681, my lord. (682), second last para. There shall be interim stay.
Did they last call you for the investigation?
My lord, this time we had gone there. We have appeared, and my lord, on 3rd January, both of us have gone there and appeared before the CGM court there, and the charges have been framed against us. Yeah. So, my lord, that is why I was humbly pleading the other day that kindly that grant us a. So let there be interim stay on further proceedings.
Now, stay of the proceedings of
My lord, parallelly criminal proceedings cannot continue. My lord, parallelly, it is not advisable in criminal jurisprudence that a lower court and a
No order.
my lord, kindly, my lord,
Yes.
my lord,
See, now the court has taken cognizance, at least the charge sheet has been filed there. Okay, we will look into it, first serve the other side. Let's hear them.
my lord, in Anant Kumar Mohta, my lord, my lord,
Next, serve the parties.
my lord, I will surely serve.
We have passed an order, Mr. Chadha, we have expressed ourselves. Okay?
My lord, kindly interim stay may kindly be granted.
12th February, sir.
12th February.
55
Hello.
Jan, 56.
Yes, let me come to the hearing of matter. Yes.
Lord, this is that matter, Lord, where the arbitrator holds
that he has no jurisdiction after he was appointed, my lord, by the Supreme Court. As a matter of fact, I should have placed it before your lordships, the evidence affidavit that they had filed before the honorable arbitrator. It specifically says that the reference of the dispute to arbitration has become final. Yes, lordship. I just pass it on. No.
I have filed my compilation. Not sure about the depositions and what has been said.
Doesn't matter, I'll just show it. It's your witness's affidavit. I'm not reading the cross-examination. It's the affidavit itself. It doesn't matter. I'll just show it now. One time you can. Yes, but my lord, there was a dispute in family. They are two brothers. There were 3 properties, my lord, which had to be distributed. Properties were there was actually an award passed by a set of 5 arbitrators appointed by them in their temple. They passed an award, and thereafter the parties did 2 things. They did a settlement agreement, they did a gift deed of the properties because one property was owned by one based on the first award. And they entered into something called a memorandum of family settlement, by virtue of which they agreed everything is resolved, settled and closed. All 3 documents were registered. In the memorandum of family settlement, there was an arbitration clause. Now, my learned friend's client filed a suit saying that the gift deed and the settlement deed are vitiated by fraud. And therefore, I thought it was only an arbitral award which was being registered, because he acknowledges the arbitral award and what is contained there. And therefore, he files a suit. Therefore, an application is filed saying there's an arbitration clause. If at all, parties must be referred to arbitration. We filed an application. The court passed an order accepting it and saying it must be referred to arbitration, against which they filed a writ petition in the High Court challenging that order. That writ petition was dismissed, saying there's an arbitration clause. If you want, you raise the issue before the arbitrator. They went to the Supreme Court dismissed it. Then they came back and made an application under Section 11 for appointment of an arbitrator. They filed the application. That application, of course, strangely not, we contested. We contested saying it is not arbitrable, and that arbitration clause is really of no consequence. Whatever good or bad reason, it was raised. That was rejected, saying you've made an application under Section 8. You cannot now argue to the contrary, and therefore that objection was rejected and an arbitrator was appointed. We went to the Supreme Court, challenging that order. Again, Lord, I really can't explain the reasons behind it, but we went to Supreme Court. Supreme Court said, no, arbitral appointment is correct, and therefore the arbitrator appointment was confirmed, and his honorable arbitrator was appointed as the arbitrator. The matter came back. They were the claimant. They filed their claim. They were the claimant. They filed the claim, and in the claim they said, this is the arbitration clause. The arbitrator must proceed with the arbitration. We filed our defense. Of course, there was some issue in arbitrability which was raised, which of course the arbitrator finally never answered. Evidence was led by them. Evidence was led by us, including the evidence of the arbitrators who had arbitrated the original dispute. Also gave evidence to say that certain amount of money which had to be paid to him was also paid. All that evidence was before the arbitrator. Then, my lord, argument started. I argued. I was there in the arbitration. I argued. Then the other side argued. When the other side argued, they said in the memorandum of family settlement, the date on which the stamp paper was purchased was 1 day after the date on the document. So if it was 21st, the stamp paper is 22nd. How is it possible there is fraud? To which we have pointed out that though there may be a mistake in the date on the stamp paper or on the date, the document was registered 7 days later in the sub-registrar, and he had gone to the sub-registrar office, everyone had signed it, registered, and everything is done. Therefore, that date really becomes ineffective. The honorable arbitrator at that point in time, either my lord, he should have said it's a completely illegal document, fraudulent document. He doesn't say that. He says, I do not know who's committed fraud or whatever. Oh, I don't want to be really in this entire thing. I have no jurisdiction. Based on that one fact, that one particular date issue, he says, I don't have jurisdiction. Thing. Yes, my lord, he should say, my lord, who should commit fraud? Either I should commit fraud on him or he should commit fraud on me. We can't commit fraud on each other. No finding. The finding is that there's no real fraud, but there's a mistake in date. in some way, my lord, the arbitrator felt very sensitive about the entire issue. But the fact was that document could never be doubted because the date on which the document was registered was subsequent to the date on which the stamp paper was purchased. And interestingly, the stamp paper was purchased by him. They pointed out for the first time at the stage of arguments. There is no pleading. They pointed out. They pointed out. There's no pleading. There is no evidence. And it's only an oral submission made on the basis of which you say that I have no jurisdiction. In my humble submission, Lord, that question of jurisdiction can never arise. You can say that document is fraudulent and therefore strike it down. That is one way. But you can never say that I don't have jurisdiction once you've been appointed on the basis of that arbitration clause. 11. That can't be there. I'll just one second. I'm so sorry. If your lordship takes that affidavit of my learned friend's client, I just want to show your lordship one paragraph in one loan, page 23, after referring to all that happened, 22 and 23. This is the affidavit filed before the arbitrator. Page. Yes, not. I think there are a number of pages. Which is this one, no? Para 9 and 10. I'll just very quickly read this. We filed a suit in OS number so and so before the file of the learned fifth additional civil judge at Bangalore seeking partition and separate possession with respect to scheduled properties. Respondent filed a written statement as an application under section 8, containing that as per clause 5.2 of the alleged memorandum of family settlement, the suit before the civil court is not maintainable, and the civil court has a mandated duty to refer the dispute arising between the parties to arbitration. Honorable Civil Court considered the application IA number 2, while its order dated 1311 observed that in the alleged memorandum of family settlement at clause 5.2, it is specifically stated that the parties have confirmed that in the event of any dispute between the parties, they shall refer the same to arbitrators, and on the basis of said findings, allow the application of respondents and refer the dispute to arbitration. Against the said order, we filed a writ petition WP number so and so before the Honorable High Court of Karnataka, and by order dated 11/3/2009, the High Court dismissed the same. Against the said order, we had filed a special leave petition for the Honorable Supreme Court of India and SLP, and the same was also dismissed by order dated so and so. Thus, the order referring the dispute to arbitration attain finality. Therefore, when this is the stand of a party, in my respectful submission, the arbitrator does not have, even if I bring out a dispute, which is not part of the arbitration clause, and there is no objection raised at that point in time, then there is a waiver of right to object under section 4 of the Arbitration Act, and there is no question of then saying that the arbitrator has no jurisdiction. Neither can the arbitrator say it himself without there being an application under section 16. And being the claimant, he could never have raised it under section 16. It only can be me, because it is only before filing of the first statement of defense.
Still contesting. Sir, what happens is, something subsequent has happened, my lord, in this suit. Now, after this order, my lord, was passed, I went to this suit, and my lord, I filed a revival application of my suit, stating that the arbitration proceedings have been terminated in this fashion. They did not object to it. Suit, my lord, came to be revived. They filed a written statement. Issues were framed. They said that issues are improper, recast the issues. They participated in the suit. Now, at their instance, my lord, the issues were recast. Now, the matter, my lord, is ripe for evidence.
It's I'll tell you, Lordship, why. Lord, what happened was we filed a 34. It is not like, my lord, we kept quiet and said, oh, we've accepted the order. We filed a 34 immediately. As soon as we filed the 34, they moved an application to revive the suit. Now, my lord, what can we do? At that point in time, they are entitled to revive the suit. I want this award to be set aside. The suit will go. The suit will automatically go. But it has to then go back to an arbitrator who can then decide this issue, one way or the other. No, because the suit, of course, my lord, has right up to the Supreme Court been held, has to be referred to arbitration. Correct. I can't, Lord. It can't be, Lord, in a section 9. I can't ask for stay of the proceedings.
We don't know. Surely, at least for you to seek appropriate order so that your 34 can be taken to logical and needs to seek that stay of that suit. In what manner you would? That's for you to look at.
Of course, Lord. Now the suit is not decided. It is not like the suit has been decided. Suit has been going on one side. Had the suit been decided, it was another issue.
Today, your lordship see a unique scenario where the suit is not decided. The arbitrator's approach, my lord, is completely incorrect. Now, the consequence of this being considered by your lordship will be that that order will of the court reviving it was only simpliciter on the basis that the award says I have no jurisdiction, which means that there's no arbitration clause.
My lord, along with the memo, on 3rd of December 2024, my lord, page number 24, no, that is said somewhere. Page number 24 of my compilation, which I have filed on 3/12/2020. Third, page number 24, no, sir. It's an order on IANA section 151C, dated 5/1/2018. Where are their contentions? So their contentions, my lord, are not. On the other hand, my lord, it says that objections have not been filed.
Plaintiff has not filed objections.
Objections are not filed, and there is a revival of the suit. This happens, my lord, on 5/1/2018. Please see, my lord, the next page at page number 27. That is the written statement. A detailed written statement is filed by them on 23/4/2019, touching upon the merits of the case.
Yes. I had no option.
What does it mean? That suit has been revived?
Suit has been revived.
That's the effect of.
Yes, yes, suit has been.
Thereafter, you file a written statement.
We file a written statement, not on merits, yes, on everything, which is the same thing as you took. Of course, I couldn't take a chance then of saying, no, I won't file my written statement. My stand also has been that the arbitral, of course, we referred again to the arbitration clause. But the fact not is, by that time, my 34 was pending. Therefore, what?
Had you stopped there?
No, it's not stopping there. It's not. 34, lots of mechanics. Page 19. The findings, Lord. Page at, start at page 34. Please see page 33, my lord. 8, the points that are made, frame for consideration. Whether one's arbitral tribunal was constituted is affirmed by the Honorable High Court, and Apex Court is not open to the arbitral tribunal to adjudicate on the question of validity of arbitration agreement or clause. So the answer in my humble submission is very simple. Unless someone raises it as an issue, it can't go into the question. But your lordship also recollect, at that point in time, my lord, orders of the court under section 11 were judicial orders. After the 7-judge bench judgment, they were judicial orders. They were not administrative orders. Even now, of course, they say it's an administrative order. But at that time, it was judicial order. Therefore, one could never answer or provide an answer contrary to it, even if it was raised before the arbitrator. Therefore, that was the simple question, Lord, which was there before the court. Court answers it saying, no, it can. Please see, my lord, first. Yes. Nothing, Lord. It was not even raised there. That was not even an objection raised by my learned friend before the.
Possibly judicial notice can be taken on. The subsequent events. Now, how would you like this? We are putting it to you.
Yes, Lord.
And now in the subsequent facts being there, what would be how this order now you can challenge it, or whether this court can set aside in view of the subsequent.
My lord, may I just put it this way, my lord? Suppose, my lord, I make an application under section 8 before the court, and the court dismisses it. I file a revision before the High Court and come in a writ petition which is pending for some time. I obviously, my lord, must file my written statement immediately thereafter. Suit goes into trial, and after, my lord, many years before the suit is adjudicated, High Court says, no, there's an arbitration clause, you cannot proceed. Therefore, we close the entire proceedings. It is in my respectful submission no different. And says,
this first, in any case, section 8 will come, followed by written statement, because pendency of section 8 will not stop your limitation for written statement.
correct, it won't stop. So I have to go through. Now, my lord, please see the situation here. Now the arbitrator says I have no jurisdiction because according to him, there's no arbitration clause. That is what he says, which means that all the orders which have been passed are wrong. That is the order of the civil court, the order of the High Court, the order of the Supreme Court are all wrong. Twice over. One in the section 8 proceedings, one in the section 11 proceedings are all wrong. And therefore the arbitrator now says I have no jurisdiction because there's no arbitration clause. Now, until that order is set aside, if the suit is revived, I have to protect my interests. And therefore I must file my written statement and take whatever steps that is required to be taken. Beg your pardon, Lord? I filed it. Yeah, in the same compilation. Yes, Lord. The written statement is filed on 23/4/2019. Arbitrator's order, my lord, is 5/4/2017. My 34, my lord, was filed on 4/7/2017. Written statement is filed in 2019. 23/4/2019. My 34 was already there. 34 was pending. And I was arguing my 34. It is not like, my lord, I said I abandoned my 34 and said I won't argue my 34. My 34 was first. Then they revived. Then, my lord, I was notified. Then I appeared. And thereafter, my lord, I filed my written statement. Therefore, in terms of timing, my lord, I was first in terms of 34, which means I was pursuing that course. Whether, my lord, I should have sought for stay or not, my lord, personally, I have some reservation on whether I can do it. Now the remedy will be, if your lordship sets aside this award, then the consequence, my lord, will be the suit will go. The suit will go. Suit will go, which means we must go back to arbitration. As your lordships know, my lord, if a 34 order sets aside an award, then the consequences, you can restart the arbitration because it is not a setting aside on merits, but on some other grounds, such as jurisdiction in this case. If it goes on that basis, then it is nothing but we come back to arbitration and restart the arbitration without going into all these questions. And therefore, my lord, in my respectful submission, it cannot be a scenario where because I have now participated in the suit, my right to challenge the award is gone. My written statement, my learned friend has filed.
Filing 34 and
No, 34, I don't think. No, it was not said. It was not said. It was not said there. That is clear.
Section 8 is filed.
My lord.
Then your section 8 will not stop the limitation and you need to
Yes,
necessarily file.
I have to file the review.
Section 8 is, I'm filing it because limitation is running against it.
As a matter of fact, not now 16, they've said you can file it along with the written statement as well. A 16 and a written statement can be filed on the same day because it says at or prior to the filing of the first statement of defense. Therefore, even at that point in time, it's done. And your lordship know many times we file them. We file the written statement because I can't exceed, if it's especially the commercial court, I can't avoid the 120 days. We do not know how the court will decide that question. And therefore, in terms of timing, my lord, I had no option. I filed it. I filed it on merits. Suppose I lose all through, I can't be in a situation worse off without my defense being on record. Therefore, my written statement is there. I've pointed out the fact that that there is an arbitration clause as well. That is also one of the defenses taken. The written statement, my learned friend has filed in that. My lord.
say anything without prejudice, don't protect your rights, not to pursue your 34. What would be the effect insofar as that written statement is concerned that must be construed to be your stand on merits insofar as the dispute is concerned before the civil court?
Yes, it is. It is, my lord. It is my stand insofar as merits are concerned before the civil court. Suppose my lordships also dismiss it tomorrow, my appeal on, let's say, on merits. I'm saying, not in this case, my lord, but I'm saying in a general case where a 34 award is being challenged. The lordship's fine. That there's no merit, I'm going to go back to the suit and continue it. But the point today, my lord, is really one of, if I may say so, of some kind of strange public policy, where your lordships have 3 orders of 3 judicial fora, twice over, being set it not by the arbitrator, by ultimately saying that there's no jurisdiction. Of course, not the honorable arbitrator was within jurisdiction to say that the entire agreement is vitiated by fraud. There was no difficulty. He's entitled to make a finding, but that's not a finding here. Then that is not a question of jurisdiction. That is a question of exercise of jurisdiction into the merits and then making a determination. In the absence of that, today your lordships have a scenario where if at all this award is to be upheld, then your lordships practically have to say that all 3 orders are wrong. Order of the civil judge, order of the High Court, order of the Supreme Court, and again the order of the High Court in 11 and the order of the Supreme Court in 11. All of them would be wrong. That can never be, in my humble submission, the consequence of something of this kind.
That may not be. I'll just give a couple of more dates in my note. I'll answer. Then the thing is,
There are further dates also.
2 dates, my lord, which shows that, my lord, there is yet again, my lord, participation on the part of the appellant here in the suit. My lord, the issues were.
We have to put it to him also.
Yes.
Something, like what you have said that now it's their case on section 8, arbitration clause. Then again, when you file 11, the arbitrator appointed, they went to Supreme Court. Similarly, you also take a particular stand and then take a.
I must bring to my lord's notice that aspect of section 16 was kept open when section 8 application had been decided. This honorable court, my lord, did not shut out the aspect of the jurisdiction. On the other hand, my lord, when my specific case was brought.
Tell us this,
Please.
going by what Mr. Chinnappa is asking.
Please.
Now, the learned arbitrator only says he doesn't have the jurisdiction.
Please. Yes.
Now, so it's basically primarily on the basis of that particular date.
Of an anti-dated document which comes.
Any finding that this has been initiated by fraud, the settlement, whatever the family settlement, which has the arbitration clause, any finding of that.
Well, he says that this document on a given day could not have come into existence, having regard to the fact that the stamp paper have been subsequently purchased.
Now, does he say so? He has been appointed under section 11?
Well, certainly he says so.
That's right. So how, and that's a judicial order, mind it.
Well, I quite see that.
There is a stamp of judicial authority insofar as the appointment is.
Please, but my submission, when section 8 application was being held by the honorable court, the aspect of section 16 had been kept open.
You have to raise it.
Urged before the arbitrator.
You didn't raise it.
Well, I'll just point out that order, my lord, so that it will clear the complete air. It was not a case.
After section 8,
Please.
matter went to 11.
Yes, because there
At his
was-
instance, at his instance.
My lord, this honorable court observed that all aspects, including the one of jurisdiction, can be gone into by the arbitrator. Because the very document, my lord, which comprised the arbitration clause itself was challenged by the on the ground of fraud.
But does section 11 order say section 16 is open?
No.
My lord, the honorable apex court said that all contentions of both the parties are kept open.
Did you file any section 16? See, 11 is at your behest.
My lord, of course,
So
section
you
11.
can't file section 16.
My lord, when section 11, my lord, was allowed, they took the matter to the honorable apex court. Honorable apex court, my lord, all the contentions are kept open was the specific observation that was made. And my lord, the petition came to be dismissed.
If suppose the order of the learned arbitrator is upheld,
Please.
what is the effect on section 11 order? What is the effect on the SLP
My
order?
lord, the arbitrator was well within his jurisdiction to, my lord, look into the document and say whether it has got a jurisdiction or not. That's the question on which he could have ruled, and accordingly he has done it.
On what basis you are saying so?
On the basis of the fact that he says that there is no valid arbitration clause, in view of the fact that such a document could not have come into existence on 21st of June, when the stamp paper on that, it is not in
No, I've filed it, my lord, at page number 60, page number 75 of the compilation which I filed on 3rd December 24. 4th January. It's a compilation of all orders. They filed that.
After this, my lord, the Honorable Apex Court, my lord,
No.
modified it. Page number 84 says.
The-
Page number 84 it says. It
No.
goes without saying that arbitrator will
No,
consider
no.
the objections that can be raised by the petitioners as well as the respondent.
No, please see the first para of that order. That is the context. I was the petitioner before Supreme Court at page 84, my lord, para 2, page 2 of that order. Liberty is given to the petitioner, that is us, to raise all the points, including the earlier award already having been acted upon, cannot be reopened. And consider all objections, but there is no objection in jurisdiction. Yes, no, it goes without saying arbitrator will consider all objections that may be raised by the petitioners as well as the respondents. That of course, not even if I'll assume, my lord, for the sake of argument, that he's entitled to raise this issue. But he has to raise the issue. That issue is not raised. And my lord,
The section 8 order, my lord, will come to my rescue. My lord, in clear cut terms, my lord.
nobody
this
raise it
Honorable
before the
Court-
arbitrator.
Pardon? Well, because of reason, because of the tenor of the order passed on section 8, my lord, I had no other option, my lord, to get the appointment of an arbitrator.
And you
Now
stuck with
see
it.
the contention of the appellant there.
Then you can't go back and rely on 8 order.
No, my lord, now I need an adjudication at, my lord, at some forum. Now here is a case, my lord, where.
Even this party, they don't want, finality to the dispute. It appears, keep it pending. One objection taken, then they resile out of that objection, go to the Supreme Court also against 11. After filing 8, you also say 8 accepted, file 11. Now again this.
Now ultimately arbitrator, my lord, takes a conscious decision. That I will not go into this agreement because this could not have come into existence on a given day. This is what he said. This agreement, which comprises the arbitration clause, could not have come into existence on a given day. This is what he said.
Who had purchased the stamp duty?
And then I had purchased the stamp duty, but the point is also, now what happens is I have specifically
Fine.
challenged that on the ground of fraud. I have challenged that on the
Whose fraud?
ground of fraud. And I took up the contention before this honorable court when I was arguing the section 8 application.
What is the foundational facts for fraud?
My lord, I have laid it. My lord, when the
Not one
arbitration
word.
award, my lord, was asked on 28/3/2007, when the arbitrators of our society, my lord, had entered into an award. My lord, they specifically say that there is a long-standing dispute and let there be a kind of an arrangement between the two brothers.
So suddenly, my lord, a gift deed would come into existence on 21/6, as if I donate the property belonging to me in favor of the appellant.
Registered gift deed.
Application of law, please, is based on the date of purchase of the stamp.
No.
My lord, certainly for this reason, because my lord, the
It's-
agreement would.
Sorry, not one pleading, not one pleading. Oh,
My
sorry.
lord, the agreement, my lord, will specifically mention the date as 21/6/2007 in relation to the registered gift deed as well as the family partition deed. It's a registered document on 21/6, but the very stamp paper, my lord, have been purchased on 22/6. And this is where, my lord, the arbitrator also looked into the fact whether it could be a typographical error or by mistake the dates have been wrongly given. Then he looked into and also the other evidences and said that if there are two registered instruments and a reference is borne to it by a document having a particular date, which could not have been drawn on the stamp paper because it was not even purchased then that clause that agreement which comprises the clause of an arbitration is something that I'm not going to look into.
Purchase the stamp duty?
Yes.
What according to you was it?
22nd of June 2007.
That according to you?
Yes, that is borne by the document itself.
But have you taken a substantive or a positive statement was made that you had actually purchased it on 22nd?
No, not one pleading. I can tell you, Lordship, without any fear of contradiction, there's not one pleading, there's not one statement in evidence. And if you Lordship look at the document, it'll become very clear. I don't know why the award was made in that fashion, but please see the date, my lord. This is at page number 1 of the documents. 21st of June, 2007. 21 is written by hand. I'm sorry, my lord has. In the first document, in that same set, my lord, of the orders, Memorandum of Family Settlement, 21st day of June 2007. If my lord kindly turns over the page.
Please observe.
One second. Yeah, I'm showing it. Correct. My reference is right. Yes, it's there on the first page itself. 22nd June on the top, on the stamp paper, 22nd June 2007. But the date is written in hand. I'm sorry. Lordship's got that?
Yes.
On the stamp paper, my lord, which is bought by Ashok Kumar, and your lordship will see who has purchased it, is also written on top. Ashok Kumar is my learned friend's client.
Stamp is
22nd. No, this is Ashok. Yeah. In your, there's another one of, sorry. Where's the one where he has paid it? No, this, my lord, was not sufficiently stamped. Then, my lord, I kindly turn on the next page. In Kannada, my lord, the endorsement, then Narendra Kumar has paid the deficit stamp duty. And then, most interestingly, if my lord comes to page 4, the date of registration of this document is borne out. Please see on the top, my lord, it's the date of registration is 31/7/2007. The registration date is 31/7/2007. That is the day on which all parties went to the office of the sub-registrar and registered this document on 31/7. Therefore, the date on the page 1 of that document was rendered of no consequence. Because it was not as if the stamp paper was purchased after the registration, which could never have happened. And Narendra Kumar pays this deficit stamp duty in this case, in the office of the sub-registrar on the 31st, on 31/7/2007. At page 2.
Yes. Now let's see the.
Yes.
Point out a particular paragraph in the document and then, my lord, please come to, my lord, page number 7 of that compilation. That's a recital, my lord, concerning the partition and the release of the properties. Page number 7 of that compilation. Part and parcel of this memorandum of family settlement. The parties now agrees as follows. That is how the page commences. Please see that partition and release of the properties. The first and second parties agreed that their residential property and being a residential house at property bearing number so and so of Bangalore Mahanagar Palika Division 50 and their factory premises bearing property so and so of BBMP has already been settled and partitioned in terms of the gift deed dated 21st June 2007 and deed of partition dated 21st June 2007, both of which have been duly registered. This is the specific recital, my lord, that it had. Now, here is a case, my lord, where the appellant has purchased the stamp paper on 22nd of June 2007. So this is what, my lord, raised in the mind of the learned arbitrator.
But it's like this, if that stamp was put rightly, and it had shown 21st June 2007, everything would fall in place. So only that date which made the difference.
That's a crucial aspect, because he says, I will not look into an antedated document.
Now let's see that.
Points in consideration. Award of the arbitrator. Page 53. Page 53, my lord, of the appeal. Arbitrator, my lord.
64.
Sorry,
64.
53. Well, it starts at 53. no? Starts at 53. The award of the arbitrator starts at 53. Please see para 5, my lord, at page 64. Para 64, page 5 onwards, my lord. Page 64, para 5. Page 64, para 5.
Top of that page.
Very good.
Order.
May I
I am
just-
making it absolutely clear, that is how it is. Page number 64, the first line. I'm making it
Not a word
absolutely
is-
clear that not a word is being referred to in course of this order with regard to the merits of the case and with regard to the correctness or otherwise of the other conditions of the parties. That is for the reason that I am unable to reconcile to the fact that document containing arbitration clause is the memorandum of family settlement is a valid document. Its validity aspect being referred to by me, not in relation to the allegations of fraud or otherwise as put forth by the parties, but with regard to the day on which it is supposed to have come into existence.
But after that, actually, 69, 69, there is,
Next relevant would be my page number 66, paragraph number 6. It starts from this manner, in absence of a clause in the agreement between the parties with regard to referring of the dispute to the arbitration, no jurisdiction vests with the arbitral tribunal. Obviously, such agreement between the parties should be a valid agreement enforceable in law. For the consideration of an object of an agreement being unlawful, Section 23 of the Contract Act, inter-alia, refers to the court, recording it as immoral or opposed to the public policy. Here is a document titled as Memorandum of Family Settlement, being shown to have been executed on 21/6/2007. Clause 5 of the said document deals with an arbitration agreement. The stamp papers for which the document clearly show that the said stamp papers were purchased by Sri Narendra Kumar on next day, that is on 22nd June 2007. I am referring to the evidence on this aspect for the limited purpose of accepting the validity or otherwise of this document. One of the arbitrators as well as one of the assisting witnesses, R.W. Sri A.D. Rukhana, in paragraph 6 of his affidavit, by way of examination in chief, states that he was informed that there was another document called the Memorandum of Family Settlement, which was signed on the same day, but that it was, however, informed to them that the document would be registered only after the money to be paid by Sri Ashok Kumar and his family was paid to Sri Narendra Kumar and his family. Similarly, another such arbitrator and attestor, R.W. Sri Prafula Raja, in his affidavit by way of examination in chief in para 7, states that the parties had also decided to sign another document called the Memorandum of Family Settlement on the same day, but only after money was paid by Ashok Kumar and his wife to Narendra Kumar and his wife. Then the extrinsic evidence is there to show that on the very day, that is on 21/6/2007, in the night, in the presence of the said elders of the community, Sri Ashok Kumar paid rupees 10 lakhs to Sri Narendra Kumar. It was thus not just accidental that though the stamp papers were purchased on 22/6/2007, the date was by oversight mentioned as 21/6/2007 as the date of the memorandum of family settlement. As per the case put forth, there had to be necessarily a document styled as memorandum of family settlement, shown to have come into existence on the very day the gift deed and partition deed came into existence, that is 21/6/2007. Though its registration was intended to be delayed until the payment was made by Sri Ashok Kumar, and it is then that evidence is led to show that the very night Sri Ashok Kumar paid rupees 10 lakhs to Sri Narendra Kumar, thus showing the date of execution of memorandum of family settlement as 21/6/2007. But the document prepared on any day between 22/6/2007 and 31/6/2007 is not by inadvertence. It is intentional in the sense that they had to bring up a document purporting to have been executed on 21/6/2007. But that exercise of bringing of that document happened subsequently on any day between 22/6/2007 and 31/7/2007. Thus, the document was intentionally got.
Now tell us one thing now, what do you intend to proceed with the civil suit, or you are?
My lord,
You are still can, avail in the arbitral.
My lord, I am intending, my lord, to prosecute the civil suit because we have made substantial advancement here. Issues have been framed and, my lord, it has been recasted at the behest of the appellants here.
What was the stage before the arbitrator?
Arbitrator, the entire evidence was completed, it was final arguments. I argued everything and then this award comes. We do not even know how this award came. We argued the matter on merits. Finally, no application, nothing was there, my lord. I led evidence of 5 witnesses. They led evidence of 2 witnesses. Cross-examination. I have extensive cross-examination. I've given lordships. Everything done. Documents marked.
There would be a fresh evidence now.
Yes, it'll have to be fresh evidence.
Has to be.
It will be fresh evidence before an arbitrator, my lord, because that order of the Supreme Court can't be undone. That there is an arbitration clause. And therefore, as your lordship know, if a 34 set aside, that entire period is excluded for the purpose of limitation under 43. And then we go back to arbitration. That's the only way we can resolve it. It can't be done in this particular fashion of going back to a civil court.
Section 8 application, my lord, have been led by the Honorable.
Yes,
No objection on this by any of the party before the arbitrator.
not a word. On the dates, not a word. Not in his as a matter of fact, the allegations of fraud are as vague as can be. As vague as can be and had nothing to do with the dates. Now, how does an arbitrator, my lord, without even pleadings or evidence, make this finding? No finding on fraud. Finally, the arbitrator says, I don't think either party had any criminal intention to defraud each other, but they got up a document. I can get up a document. If both parties have agreed on a document, there's nothing wrong in it. Unless it is found to be a fraudulent document or a document which is against the provisions of the Contract Act. There's nothing against the provisions of the Contract Act. Parties have said, you've got this property, I've got this property, we've settled the dispute.
So,
March, they hardly come to the civil court, my lord, from what I'm told.
now, let this submission not be made. We do.
So want the order
because
sheet?
ultimately-
You want to see the order sheet?
Please,
I'll show it.
Absolutely, my lord, what has happened is an application has been filed by us saying that there should be depositing of certain rents, and my lord, on that application, the matter had gone up to passing of the orders, and then my lord, it could not be passed. Now, on hearing of that application, my lord, the matter is, that is how the matter is going.
Now it's in March.
Yes. Oh, my lord, issues are recasted at that behest. My lord, burden is, my lord, now put on me to show that these documents are fraudulent. And my lord, the very document, my lord, which contains this arbitration clause is itself, my lord, a document that I have challenged. So this is an aspect, my lord, that is now being gone by the civil court.
That was challenged before the arbitrator as well.
On the issue on fraud, even before the civil court, we have a hearing.
On which one, my lord?
Arbitrator.
Yes.
On the date.
My lord, now, yes, in a way, he says the document is neither here nor there. It is got up. He casts a doubt on the document and leaves it there. He says, I don't want to be a party to it. Your lordship saw the language in the award. He says, I don't want to be a party to such a thing, but I don't say it's fraud between the parties. because both parties cooperated with each other in creating the document. Therefore, I asked myself, not either I should defraud him or he should defraud me. How do we defraud each other in a document and say, this is a document we've defrauded each other and document, therefore, an arbitrator can't decide on? That's precisely what the honorable arbitrator is saying. I respectfully, my lord, must say that that kind of finding could never have been made. In the absence of pleadings, I should have a chance then to respond to it. If I had the chance to respond to pleadings which they have explained, today, after I argue the entire matter on merits, award comes saying I have no jurisdiction. I heard extensively, my learned friend wasn't there at that point in time, but of course, my learned friend would possibly be instructed by his father who was there, my lord, at that point in time. But this matter was argued extensively. I argued it myself. Therefore, I argued at least on 3 days of this, because that much of evidence was there on record before the arbitrator.
Any date put by the stamp vendor?
Yes, that's the date on top of the stamp paper.
But by hand.
No, 22nd June 2007 on top.
Yes.
That is the date by with a seal, Lord. At that point in time, it's a seal. It's a seal. That's all. Now, my lord, many a times your lordships know, my lord, a document is prepared. When we go for registration, on that day a date has to be entered. Now, parties, we do not know after several years when a party is asked, why did you put that date? If you, at least if they ask me in cross-examination, not asked. It was not like in cross-examination, a question was put, oh, you put this date of 21st. But then the point, Lord, is, and which has not been answered by the honorable arbitrator is, this document was not registered on that date. Document was registered on 31st, 10 days later. Now, if I, on the date, I don't know if I put it or the sub-registrar put it or whoever put it, said, give a date, put a date on the document. They put a date on the document. Now, if they had raised the issue, then an argument is possible that I'll respond to it. Without an issue being raised, no issue being framed on that question, straight away you proceed to say, now I don't have jurisdiction to adjudicate as to whether this document is fraudulent at all.
Continue the arbitration.
Well, the civil suit matter has in progress. Well, we can manage put an end to this. Now, the learned senior is saying, well, certain things were not done to him. Now everything is put to him. Please.
The time fact.
Well, the civil suit might not be directed to.
And again, the civil suit is at the evidence stage of issues have been. Here, the final argument stage, everything is on record, even the evidence is on record.
Now, my lord, the mandate, my lord, is to be given to a fresh arbitrator. My lord, the very same evidence, my lord, cannot be looked into. That will be the difficulty. Now, we need to lead our evidence afresh. My lord, we need to start the entire process.
We can, if we agree.
First, contrary saying that now everything has to be de novo. By a fresh new arbitrator. There will be something on record. Possibly you will start from the subject to what you say, both of you. See from the stage where the earlier arbitrator has left. Possible.
Well, now the arbitrator says, my lord, we cannot look into this agreement. Because, my lord, the series of, my lord, chain of events he speaks about. Now, of course, my lord, learned senior would say that it was not put to me. But would that, my lord, take away the effect of, my lord, now to say that the arbitrator nevertheless will have to look into an agreement, which could not have come up on a given day.
But no one had raised this issue.
Nevertheless, my lord, when I took up this contention of fraud, this honorable court specifically said that this is also an aspect that could be looked into by an arbitrator. And an arbitrator, my lord, feels it fit to first find out, my lord, whether there is a valid arbitration agreement or not.
Well, in the context, not in the context of the date of the stand.
My lord, this agreement itself, my lord, is a subject matter of challenge on the ground of law. My lord, these aspects, my lord, also will go into it because I just read out, my lord, that a portion of the order. The arbitrators come and say there that some amount had been paid on the very same day. Now they had to, my lord, invariably put the date as 21 June 2007. And that is where the arbitrator says that it was intentional. It was not an accident. So why 21/6/2007 had to be the date? Because they had it.
Where put the date?
Obviously, they have put it. I
Well,
have said that this is an
That's not the case you've made out. How do you make that assumption?
case that I have made up.
No.
This document has been fraudulently obtained by me.
With your case that you had put the date on 21 and the stamp duty was 22nd?
No, that is not the case, but what I have said is, contrary to what was initially agreed upon, when the award had been passed by the elder members of my community, totally contrary to that, when the law had already been passed, they said that arbitration award had to be registered. They took me there and got a gift deed obtained from me. Now, where was this out of love and affection flowing in the document is something that I challenge. Now, I also said that what has been said as a memorandum of family settlement actually was the foundational document on which those two documents had to spring out of. And consequently, I said that this itself is a product of fraud. This is how I structured my case.
So was your case? Where did you say so?
Page 14, my lord, of the documents. Page 14 and then amended is at page 20.
Paragraph number 2, page number 21. Please, paragraph number 2. As the disputes, that's how it begins. As the disputes arose between the claimants.
Yes.
As the disputes arose between the claimants and the respondents, they sought to resolve the same through arbitration, and even an arbitral award came to be passed on 2018. A copy of the same is the document. The respondents told the claimants that the arbitral award had to be registered and took them to the office of Condemnation. There, the signatures of the claimants were taken on some documents, and thereafter, the respondent said that the arbitral award is registered and it has become a valid document. Even the respondents occupied the whole of the Schedule B property and made claimants move to another rented house. A sum of ₹34 lakhs had to be paid to the claimants to move to another house. A sum of ₹34 lakhs had to be paid to the claimants by the respondents in relation to the scheduled property. No amount was paid by the respondents to the claimants. The claimants were surprised by the development. The claimants questioned about this, so that respondents started giving evasive answers. In the meantime, there was a public notice published in Hindu newspaper publication dated 17/7/2008, and it read that respondents were contemplating to sell 5 to 4 lakh area with certain measurements of a scheduled property, herein as belonging to them. The claimants were shocked and surprised. They immediately approached respondents and questioned about it, but respondents even refused to talk to the claimants. Suspecting foul play, the claimants made inquiries at the sub-registrar office and found that respondents have created gift deed and partition deed by practicing fraud and resorting to the certified copy of the said gift deed and partition deed is at home. As disputes had arisen between the parties and even they had approached the arbitrators, there was nothing like existence of love and affection for the first claimant to execute the gift deed at document number 2 in favor of first respondent. It is clearly vitiated by fraud and misrepresentation. Further, a mere perusal of the alleged partition deed at document number 4 would reveal that alleged partition is unjust and unequal. In fact, it gives unfair advantage to the respondents. Fraud has been played on the claimants even by taking signatures of daughters of claimants as consenting witnesses. The claimants were not well versed in the legal procedures, had been taken for a ride by the respondents, and undue advantage has been taken of their innocence. And there is no gift or partition in the eye of the law. In fact, it is non-net. Hence, suit for partition is separate.
There is no mention of the memorandum of family settlement at all. They don't even refer to any fraud being committed with respect to the memorandum of family settlement, not one word in the entire claim statement. And on the contrary, my lord, please see.
And Naren.
Now, how would you answer para 6? Cause of error on 21/6 when fraud was played and misrepresentation was resorted to on the claimants of the proceeding. Now, what is the relevance of 21/6 here?
21/6 is the date on which this alleged documents came.
Not alleged.
So, you are concerned, you agree that 21/6.
21/6 is the date, my lord, on which these documents have come into existence. That is what my lord is challenged.
No.
Please see the prayer, my lord, in the claim
No,
statement.
forget the prayer.
Please see paragraph, page number 24. AA, my lord, is added to say that to declare the partition deed dated 21/6/2007, gift deed dated 21/6/2007. So you were, and
basically on the gift deed and the.
Precisely. The suit was only to declare the gift deed and partition deed as invalid. The suit was brought back here. The same language of the suit was filed here. As a matter of fact, your lordship will see there is not one statement that the memorandum of family settlement is vitiated by fraud, either because of dates or otherwise. On the contrary, they say, your lordship will kindly see para 7 and 8, para 6, 7 and 8, page 23, about 4 lines from the top. Respondents, my lord, got that? Respondents filed a written statement application under section 8 contending that as per clause 5.2 of the alleged memorandum of family settlement, suit before civil court is not maintainable. Civil court has a mandatory duty to refer the dispute arising to arbitration. Civil court considered the IA 1311/2008 observed in the alleged memorandum of family settlement. It is specifically stated parties have confirmed in the event of any dispute between the parties, they shall refer the same to arbitrators. And on the basis of said findings, allow the application, refer the dispute to arbitration. Then against order, writ petition is filed, SLP is filed. The order referring the dispute to arbitration attained finality at para 8. In this regard, claimants filed CMP 13 of 2010 before the Honorable High Court seeking appointment of an impartial arbitrator to settle the disputes between the parties. Honorable High Court was pleased to appoint this arbitrator as the sole arbitrator. Order was challenged before the Supreme Court and SLP. Supreme Court passed an order and upheld the order of the Honorable High Court at Bangalore, and hence this claim statement. Not one word about the memorandum of family settlement anywhere.
Page number 45, paragraph number 6.
That's in the claim statement.
Well, that is the rejoinder that I filed. Once their objection is filed. Page number 45, paragraph number 6. It commences from the word actually. Actually, 2 documents had been registered on the same day, stating that there are 2 properties, and in respect of each property, there has to be registration of award.
Nothing.
At that time, the claimants did not know as to on how many documents their signatures were taken, as they had bona fide believed that arbitral award may require to be registered, as they had not consulted any advocate at that point of time. In fact, almost 40 days later, the respondents had even called the claimants to sub-registrar office, telling that a confirmation deed had to be registered in relation to the registration of award, and got a document registered. And it is that document which the respondents are claiming in their objection statement as memorandum of family settlement dated 21/6/2007. Thus, the alleged memorandum of family settlement is a product of fraud and misrepresentation. When there was already an arbitral award dated 28/3/2007, there was no need to make a gift deed or partition deed or a memorandum of family settlement. Hence, they could not have come into existence except by paying fraud and resorting to misrepresentation by respondents of the claimants. This is one aspect. These allegations are all contained in the partition. The family settlement is specifically spoken about. I have specifically said that thus the alleged memorandum of family settlement is a product of fraud and misrepresentation. Then there was already an arbitral award dated 28.
But that's the ground. That's the ground. The arbitrator must answer that ground as to whether the existence of the arbitral award vitiates this or these 3 documents. That is a question which is put forth by him to the arbitrator, but there's no answer. Arbitrator says, I have no jurisdiction, which means there's no arbitration clause. Lord, lordships know, even in a document, Lord, which may be vitiated by fraud, arbitration clause. Yes, my lord. Yes, one sentence in the rejoinder. In the rejoinder to my statement of defense, a statement is made, it is a product of fraud and misrepresentation. How? Your lordships know, my lord. Fraud has to be specifically pleaded. You must say as to how it is a product of fraud. He has given a reason. His reason is because there's an arbitral award, there was no need to register these documents. Therefore, merits. Answer is that a justifiable ground to hold? It is fraud. That the arbitrator can certainly say. Suppose the arbitrator says, my lord, yes, there was an arbitral award already in place. Therefore, the question of executing these documents could never have arisen. You have taken these poor individuals with their daughters to a sub-registrar's office, got 3 documents signed, and they got it registered. And in evidence have come out, my lord, as to how his daughter is a chartered accountant, one is a doctor. All of them, my lord, are very well educated persons. All of them know what they are signing, and everyone spoke in English, answered all questions in English. Therefore, to say that I did not know what I was signing, in my humble submission in retrospect, is a completely wrong statement being made. And merely making one statement, Well, I'll take it for as an argument. Suppose I say a particular document is a product of fraud. It is not enough. Your lordships have always held that you must explain as to how it is fraudulent. What are the circumstances which led to the fraud? Is it the dates? If it is the dates which my learned friend is now saying, is it the dates which led to the fraud? I would have explained very clearly in my defense as to how it can't be. As to how it was registered on a particular day and the witnesses appeared before the sub-register on that day. My lord. My lord.
No, your case is that if you send back to the arbitrator. Now he says which arbitrator, that's also. an
No,
issue.
of course not.
What would be the stage? See, all these things we have to address us.
I'll address it, my lord. I'll address it, my lord. Insofar as the question of whether this award can be upheld is the only issue before your lordships now, lord. The answer in my respectful submission can only be that this award in this form cannot be upheld because it answers the question of jurisdiction which it could not have. Of course, your lordships can't remand it back. Your lordships can't appoint an arbitrator at this stage. The only consequence now, my lord, will be that parties have to appoint an arbitrator. Yes, ma'am, I'll address it. Yes. Tomorrow, my lord. Lordship may have it tomorrow. I'll add it. I'll respond tomorrow. No, on this point, there's nothing else. Let me answer it tomorrow, my lord.
Could it be murdered on 10th? Tomorrow, there's something different.
Right. Great.
Yes.
Please, my lord. Lord, this is a 37 appeal. I was the respondent. I had also filed a counterclaim. I did not succeed. My 34 was also rejected. Lord, one preliminary ground, Lord, not on the award, but on the decision of the Honorable Court, would be, my lords, that the judgment is dated 9th of March 2021. It is by the regular civil court. By this time, my lords, undoubtedly commercial courts had been constituted. Of course, my lords, candidly, I have not taken that point there. And I have not even taken that point here. But, my lords, there is subsequent to the filing, there are two decisions, one of the Honorable Supreme Court and one, my lords, of the Calcutta High Court in a division bench. Both of them seem to say, my lords, that this goes to the root of the matter. And, my lords, that the decision that
Saying in the context of
34 court only, my lords, 34 court only. For that, my lords, may I just show those judgments? It is, my lords, because it is more than 1 crore. And because it is more than 1 crore, my lords, it becomes a commercial dispute. My lords, the first, yes, my lords, the first decision in the list. Not the first decision of the Honorable Supreme Court, not as I understand it is, the question there, my lords, was senior civil judges were notified as the commercial courts by Orissa, and that was challenged to be in conflict with the provisions of the Arbitration Act because it must be the district court. In that context, my lords, the Honorable Supreme Court makes various observations, including saying Commercial Courts Act, it's a later legislation and therefore will prevail over the provisions of the Arbitration Act. But since the Honorable Supreme Court has now said so, and this is in 2023, Lord, my respectful submission is the only reason why the 34 petition was filed before the civil court was because of the provisions of the Arbitration Act. It is not, my lords, emanating from civil procedure. Lords, it was the Honorable City Civil Judge, not the commercial court. The 11th Additional City Civil Judge. The decision, my lords, is at page 50.
a civil court, a district court. In a similar circumstance, my lords, division bench of the Calcutta High Court sets us, and even in that case, this point was not taken. Lords, and my respectful submission, my lords, is because of section 15 of the Commercial Courts Act, transfer was mandatory. Therefore, and my lords, my second submission is that jurisdiction of the commercial court, unlike, is not, my lords, either a pecuniary jurisdiction or territorial. Territorial, my lords, question will not arise at all. Pecuniary, although there is a limit, it turns more, my lords, on the subject matter. Even in CPC, my lords, when subject matter jurisdiction is not there, that point can be taken even collaterally. That, my lords, is my first point. Therefore, my lords, that the 34 decision, independent of the award, in light of especially the subsequent decision of the Honorable Supreme Court, that decision, my lords, may be jurisdictionally void, irrespective of whether the parameters of 34 are met or not. Notice has to be issued, my lords. It is. No, it's not yet. No, my lords, I have not. My lords, which is why I submitted, my lords, that I have not taken, but I will take it, my lords, now. I will, my lords, I will. It occurred to me, my lords, when I was. I will file, my lords. I'll file an application. Please. Please, grateful. Two weeks, my lords.
28th January,
Grateful.
till number 58. 58.
For the appellant in this matter. We need to file written submission. Even I also need a small accommodation. There is two portion of lands acquired. One is commercial land and the one is dry land. But arbitrator granted both the lands as a commercial. That is the only issue. Yeah, but that is different for commercial land as well as converted land as well as other dry land and garden. But dry land, it cannot be termed as converted land. That is the only issue. But two portions, that is 405 square meter and 445 square meter, total 850 square meter. That comes to around 20 cents, 1/5 acre. So both the land he granted residential rate only. That was the issue. Anyway, there was a direction for me to produce it.
February. Serial number 59, Shri Manjunath. 59.
My lords, I appear for the appellant. My lords, here appellant engaged the services of the respondent, my lords, to carry out the soil protection of a commercial building. My lords, this was a subcontract. The main contract was entered into between the appellant and the owner of the construction of the RNZ Eco World, my lords. The entire project was for about 351 crores. Well, the soil protection work which was entrusted to the respondent was basically to test the soil to check the load bearing for the building to be constructed, my lords. My lords, an LOA dated 27/7/2013 was entered into between the respondent and the appellant. And various variation orders, my lords, a lump sum contract value was revised. My lords, when the work was being carried out, dispute arose, my lords, and arbitration was initiated.
My lord, the contentions that we had, the appellant had taken, my lords, who was a respondent in the arbitration, was that the LOA, my lords, which is a works contract, was not stamped. Was not stamped, my lords. The second one was that second one was that, my lords, the retention money, the claim that was there by the respondent number one, was that, my lords, if I may take your lordships through the LOA, my lords, clause 5.6, which is document number 3 of the appeal memo. May I read it out, my lord? The subcontract shall be entitled to the release, page number 90, my lords. 90.
Yes.
The subcontract shall be entitled to the release of the retention money upon the expiry date of the defect notification period of soil protection work under the main contract conditions, and or the receipt of such retention money by us, whichever is later. Despite bringing the arbitrator, my lords, only claim of the only retention claim of the claimant, that is a 12 months, my lords. From the date. My lords, it was there were 2 blocks, my lords. One block was completed on 18/4/2016, and the second one was completed on 2/2/2017. Defect liability period expired on 31/2017 and 28/2/2018, my lords. And in 20, please, my lords. But then I hadn't received the money from my,
That means will that, the condition that you have to receive money.
please, my lords, the clause itself says that.
Title to release the retention on the expiry date of defect notification period of soil protection work under the main contract. The condition or
But then, my lords, it was terminated, and then we had to engage another subcontractor and then get the work. Yes, my lords. Because he did not complete within the period, my lords.
it's not complete.
Please, my lords.
Otherwise he had completed. He has not, he has gone beyond the permissible time period.
Please, my lords.
Expired time period is why he is concerned.
Please, my
But
lords.
he completed the work.
Not completely, my lords, because there were tranches, which is why the, when the deadlines were not met.
Let's see.
It's at page number 70, my lords. Page number. Page number 90, my lords.
Page 90.
Yes, my lords. Clause 5.6.
And we are only concerned with retention money.
Please, my lords, because the arbitration, the arbitral tribunal has allowed only that claim.
How much is the retention? 46 lakhs.
Please, my lords, and also in the award, my lords, if I may take your lordships to the operative portion. Point 3, my lords, the respondent is directed to pay to the claimant a sum of rupees 46 lakhs.
Let's see the finding of the paper on this provision,
Yes.
on this stipulation in the contract LOA. See this finding.
Page number 12, my lords. Page number 81, internal page number 12, page number 81.
Yes.
In regard to issue number 4 and 6 of Exhibit P2 pertains to release of retention money. The same reads as under. The subcontract shall be entitled to the retention money upon the expiry of date of defect notification of soil protection work under the main contract condition and or receipt of such retention money by us, whichever is later. PW1 has stated that the letter of acceptance stipulated that 5% of final contract sum against which bill or invoice would be withheld with the respondent as retention money. Letter of acceptance further set out that retention money would be released upon the expiry of defect notification period or on receipt of retention money by respondents, whichever is later. The claimant has sought to recover a sum of 46 lakh being retention amount from the shoring invoice, except for stating that the respondent is not due to pay any amount to claimant and much less 73 lakh. The respondent has not denied that it has retained the sum of rupees 46 lakhs from the shoring invoice. RW1 in an answer to question number 59 has admitted that the respondent had deducted around rupees 47 lakh. Therefore, it is clear that the respondent does not dispute the correctness of the quantification of the retention amount of rupees 46 lakh. So far as the defect notification period is concerned, it is not disputed that 12 months would be period for complete and acceptance by the claimant, and during the period, if any defect.
Pay the complete amount by the principal.
The owner, no, my lords, under the main contract. Not yet.
Tell me this, that you will not raise disputes, he will not release it, you will not pay it to him. And just come to page 82.
Please, my lords.
This would not be correct, no? I will not claim, but I will not pay him because I did not receive money from him. But I don't raise a claim against, I don't raise a dispute against the owner. But I will not pay him. Can't be. Come to page 80.
Please, my lords.
No, just read the 7th line, when it was put to him that under the main contract, the defect notification period for soil protection was over in 2015 itself. He replied, he has to check. So far as the non-production of the main contract, he has denied that intentionally respondent has not produced a document as the employer has released the entire retention money towards soil protection work as long back as 2015. That's the finding. That means he has released it to you. You did not pay it. Thus, we could see the papers would throw some light on the defect notification period which are in possession of the respondent and not been produced. No explanation is forthcoming for the non-production of the same. Again, if you will notice, RW1 has stated there was overall completion of the work entrusted. Even the tenants had occupied the several tenants, which would have been after the overall completion of the project. As already pointed out, now this is the only challenge.
Please, my lords, even unstamped document, my lords, the LOA, which is a works contract, has not been stamped, and this ground was also taken up before the arbitrator and even under section 34.
Let's see what is the ground. It is not arbitrable. The dispute would not have been.
It should have been.
Would not have been given effect to.
At that point in time, no, my lords.
Okay. What was the objection then?
My objection has not been.
Where is your challenge before the
Trial,
Arbitrator, on that count, let's see what was the ground.
please, my lords. Annexure G, my lords.
Yes. It is-
Had also made an application, my lords, under section 33. Yes, my lord. Yes, my lords. That is at annexure. My lords? That is not,
This, let's see this, what in what manner he.
in the award, my lords, it's at page number. It's at page number 84, my lords. Para 18 starts at page number 83 and then continues to 84. It may I read, my lords? The respondent has contended that exhibit P2, that is the LOA, my lords, should be incorporated on a stamp paper, and that has not been done, and therefore the same has to be impounded and sent to the concerned authority. It may be noted that the claim made by the claimant for the award of so-and-so has been fully satisfied, and therefore there is no necessity to look into exhibit P2. Again, the claim for recovery of rupees 4 lakh has been rejected, and therefore there is no necessity to look into exhibit P2. Page number 175, my lords, para number 31. Sorry, my lords, page number 177, my ground starts, my lords, in section 34. Page number 171 is on the issue, my lords, the first issue. Para 41.
Seventeen.
179, my lords.
17. Paragraph of it.
41 onwards, my lords, page number 179. There's a heading, my lords. Annexure N, my lords.
lords, other than this, another ground that we've taken, my lords, it was not my lord.
It was not sufficiently stamped.
It is not stamped at all, my lords. My lord, a respondent was on caveat when the appeal was filed. On the last date, we were informed that the lawyer has given NOC, my lords. My lords, that
Prashant, MV.
On which date representation was made that he has given NOC?
My lords, this was when I informed them that I want to seek time, is when they told me they've given NOC. I don't think there's anybody else who's filed wakalats for them, my lords.
The previous one.
The previous council, my lords. Prashant.
They say this we. The third respondent.
Please, my
Returnable.
19th February.
Yes. Yes.
Next day Arjun 61. Deepak 61.
The matter will be taken up on Monday, my lords. Senior advocate Mr. KG Raghun is engaged. On 13th month. Manda. My lord, it's for admission, my lord. I may be permitted to submit on 62. My lord, a blanket order of stay. No, it's my appeal. I'll just submit.
Yes, yes.
Can I submit? My lord, I'm a purchaser of a plot of land, my lord. The plaintiff before the trial court claims that he has an association of persons. Therefore, he has a right to the property belonging to my vendor. My lord, my vendor, who is in appeal number 61. 61 is my vendor, my lord. My vendor buys agricultural land. And why I'm emphasizing on this, my lord, is in Karnataka, there was a specific restriction on non-agriculturists buying agricultural property. So my vendor, who's the appellant in item number 61, has purchased agricultural land in the year 2004 under a registered sale deed. After that, my lord, he gets the land converted for non-agricultural purpose. And thereafter, he signs a registered agreement with me to sell. And after that, he executes a sale deed in my favor. The plaintiff, my lord, claims that he and my vendor formed what is called an association of persons. And therefore, he claims that he has a right to the property. Now, my lord, based on that, he produces a photocopy of a document before the trial court, saying that this is the basic document on which I'm claiming that the suit schedule property now belongs to the association of persons. My first submission, my lord, is that once there's a registered sale deed and the title holder would have to transfer it to another legal entity, that legal entity, my lord, can be transferred under section 17 of the Registration Act only by another registered document. And the trial court, my lord, based on a photocopy of a document and the relief, my lord, what the plaintiff says, this, yes, case management hearing. My submission, my lord, is, yes, my lord. I'm the defendant purchaser, my lord. No, I will. No, I will give the dates and events. No, it's not. What my learned friend is not. Can I just share the dates and events, man? No, it's my appeal. I mean, my lord, they will have the right to say on the stay, on admission, what I'm submitting, my lord, is that when the suit is filed, they seek for partition. I request my lord to kindly consider this. Their case is that it's an association of persons. They, in the cause title of the plaint, my lord is pleased to see the plaint for a moment, which is at ink page 119. Ink page 119 is the, please, my lord, plaint, my lord. That's at ink page 119. Please see ink page 119, my lord. In the plaint, it shows Mohan Kumar, son of so-and-so. Then he makes the first defendant, one Daya Associates. Now, please see. My lord, I am the purchaser, that is seventh defendant. Seventh, Anushka, and the eighth defendant, who is the representative of the seventh defendant. Now, please see, my lord, the description of parties. Two appeals. One is by my vendor, that is the second defendant, Mr. Akarsh. Yes, is by Mr. Akarsh, my vendor. Defendant number 2. Yes. I purchased this property for 64 crores. My lord is pleased to see. Yes, ma'am. Yes, yes. Now, please see the way they describe, my lord. Daya Associates, association of persons, represented by its partner. So, my lord, an association of persons, my lord, if I say that we are joining together for, because the definition is under the Income Tax Act for association of persons. 4 of us will join together and say that we want to acquire a property. That property, my lord, would be stock in trade. It will not be the property which is kept for ownership. It is meant for purchase and sale. Now, that is the case. Akarsh is shown as Mr. Akarsh so-and-so, partner of Daya Associates. The third one, Dayanidhi so-and-so, partner of Daya Associates. And the fourth person, Muniswamy Reddy, partner of Daya Associates. My lord, no, they are contention. Now, I'm happy learned senior counsel said this. Now, please see what they say in their plaint. Page 121, para 3. My lord, if it is an unregistered partnership, 69. 69. Yes. Now, please see, learned senior counsel says that it's a partnership. Now, please see para 3 of the plaint, my lord. At page 121. The defendant number 1 is an association of persons. This is contrary to what they are arguing now. Then please see, my lord, next page, 122. No, I have purchased it. Yes. All I'm saying, my lord, I have purchased. No, I will show that also to my lord. What my learned friend is saying is not absolutely right. I'll show that to my lord. Not to alienate. Not to alienate.
So far as this sale deed is concerned, it did not say anything. It had restrained you to further selling it.
No, but my lord, I am a business person. I have purchased this land for 64 crores. Now, sir, my lord, I am intending to entrust it for development. Their relief, my lord is pleased to see. Please see their relief. His relief is he's claiming 38 over 100 share. I'm saying to my lords, I will give a conditional protection to his 38 by 100. That is his claim. It cannot be a blanket order of stay. My lord, when he is claiming 38 by 100, the injunction is as against the entire land.
What was who appears for the plaintiff? Now, what was your claim, Mr. Abraham?
That the entire transaction could not have taken place, or the price that is there, the market value is not different. So that the person.
What according to you was the market price?
Actually, I'm not set out,
Your claim is for this fraction of the share only.
Yes.
I am a different number 4. I stayed with the plaintiff. I am the patriarch of the family. I am the uncle. How are you related? You are related. Yes, I am the uncle and they are nephews and nieces.
Well, there's no injunction against them. It's against me by the plaintiff. This is a collusive suit. Yes.
That share, you are seeking that share.
To partition the entire.
There is partition to that extent because it's 38 by whatever he said. And I have the
Okay.
together, both of us selling together, we can afford 61%. Of the total between both of us, 61%. But I have different number of different number.
He has not filed any counter claim. He cannot argue the case of the.
To sell it.
My lord, I intend to develop it with a third party. I will even declare in my document with regard to list pendants. I will even say to my lords that the total extent of land is this. Insofar as the plaintiff is concerned, if his consideration, my lord, my learned friend made a submission, which is again not supported by documents. My lord was pointedly placed to question as to what is the market value. Let him produce a document to show what is the market value. This consideration of 64 crores is above the guideline value. The value set out by the government, it's much higher. If he says that the property is below 64 crores, let him produce a document to say how it is above the circle rate. My submission.
The property.
Yes.
Third party rights.
Yes, my lord. My lord, I have entered into this transaction much before any suit was filed by having a registered agreement with the title holder. My lord, let them place before my lord any registered document. My lord, section 17 of the Registration Act clearly says that to acquire title to a property, you should have a registered document. And my lord, it is common to say that once there's a registered sale deed, for the plaintiff to say, I'm entitled to it. My lord, the plaintiff's case, if I may be permitted to take a few pleadings, plaintiff's case is, my lord, he says that I'm a partner. That is in page 122, line number 3. The defendant number 1 was constituted on 18/1/2004 by agreement for formation of an association of persons with the second. The third, fourth defendant as its members along with one Srinivas Reddy. So this is one of his contentions. Para 4, what he says. Yes, my lord. He says in para 4, he says that the plaintiff submits that the main objects of the first defendant is to purchase converted properties, agricultural properties. My submission is because of under the Land Reforms Act, Karnataka Land Reforms Act, 79A and B and section 80 prohibited non-agriculturists from buying agricultural land. If he says that I bought it on behalf of an AOP, then he's making an allegation that I'm a benamda. Now here, my lord, he says, the plaintiff submits that the main object of the first defendant is to purchase converted properties, agricultural properties, to develop the properties and sell them to potential buyers. Now I'm a potential buyer. I have purchased a property, so even in so far as the plaintiff is concerned, I'm buying it. Therefore, my lord, this is his argument. Now, please turn the page over, PTO page 123. At the bottom, the last 4 sentences, out of the funds belonging to first defendant, certain immovable properties situated in the villages of Sarjapur, so and so were purchased in the individual names of one or more members of the first defendant, AOP, out of the funds of the first defendant, AOP. This again, my lord, begs the question, has he produced a document to show that when the first when my vendor purchased a property, did the first defendant give my vendor the money? Yes, my lord. Yes. His share of land, 38 by 100. No. No. I would submit this, that relief of partition in an AOP does not, an AOP, according to them, even if I take their case to be entirely true according to the plaintiff, in an AOP does not. That's what, my lord, he doesn't say. He describes in the cause title that they are partners. Then he says in the pleadings that they are an AOP. AOP is defined, my lord, under Section 3 of the Income Tax Act. That is the definition where few people join together. My lord, after they join together, then the sale deed should have been registered in that AOP's name. Sale deed is registered in the name. My lord, I am on the prima facie case, balance of convenience and injury, these three principles. Prima facie case, he should show from his pleadings or a document that in 2004, based on this AOP agreement, he gave the defendant number 2 this money and said, look here, go and buy that agricultural property. Now, my lord, after the land was purchased, then the land came to be converted for non-agricultural purpose. After the land was converted for non-agricultural purpose, the mutation was effected in the name of the defendant number 2, who is my vendor. No steps were taken to mutate the property if it was an AOP in the name of the AOP. Nothing is done. There is no document. But notice my sale agreement is registered. Now, going further, the plaintiff, my lord, para 6, he says at page 124, the plaintiff submits that the said K.M. Prabhakar Reddy, one of the partners, members of the first defendant AOP, and the father of the plaintiff and the third defendant, that is, this is the son-in-law, second defendant is the son-in-law, and the third defendant, father-in-law of the second defendant, and brother of the fourth defendant, died intestate on 16/1/2018, leaving behind the plaintiff, the third defendant, and his wife, Ms. Sushila, as a surviving legal heirs. Upon the demise of the said K.M. Prabhakar Reddy, discussions were held between the surviving legal heirs in the presence of certain well-wishers and elders as to who will step into the place of late K.M. Prabhakar Reddy. Mrs. Sushila, the wife of the said late K.M. Prabhakar Reddy, expressed that she does not wish to join the business of the first defendant AOP, and accordingly, my lord, this is also important, released all her rights over the assets and the business. Now, this is again unregistered document. So if she had a right, that again under section 17, in my name, in my vendor's name. So his case is that his mother released his rights in his favor. This is what he says in page 125. And accordingly released all her rights over the assets and the business of the first defendant in favor of the plaintiff. No document. Accordingly, the first defendant AOP came to be reconstituted by way of execution or deed of reconstitution of AOP on 29/2018. Now at the bottom, they show this sharing. Plaintiff Mohan Kumar, 38%. Second defendant Akash, 20%. Third defendant, 19%. And fourth defendant, so-and-so. Now, my lord, the next page, para 9, I think page 126. The plaintiff submits that, now this is again an unsupported statement. The first defendant AOP purchased the following properties in the name of the second defendant. No recital in that sale deed. I'll show from the sale deed. Wherein the second defendant was a mere custodian of the immovable properties for and on behalf of the first defendant AOP, and the same were brought out of the funds. Now, please turn, my lord, to page 130, where they give all these property description. Para 10, relating to the suit schedule property were mutated in favor of the defendant number 2 in accordance with the respective sale deeds on behalf of defendant number 1 AOP in the capacity of one of the members, partners of the AOP and the custodian of the immovable properties for and on behalf of the first defendant. All the lands described in the suit schedule property have been accounted for in the books of accounts of the first defendant AOP, and the same is accounted as an asset of the first defendant AOP. Now, this is also important, in the form of stock in trade. My lord, this is his cause of action. He says that you are not fulfilling the 2018 agreement where I'm entitled to a share. And here, my lord, he says stock in trade. My lord, if I have a liquor shop and 10 bottles of liquor, I cannot seek partition. I can only say sell that bottle, collect the sale proceeds, and then divide the sale revenue. I cannot divide the bottles according to the convenience of the AOP partners. And there, my lord, page 131, the details of the scheduled property held as closing stock. That means it's not owned. It is of an unregistered partnership deed, section 69. By the first defendant AOP is reflected in the income tax returns filed by the income tax department along with audited financial statements of the first defendant under the signature of the members and partners of the AOP, and more particularly with the... Please, my lord. My lord, there's some urgency because, my lord, we had an, if I show, my lord, from the dates and events, and I'm willing to subject myself to terms of this honorable court, and even, my lord, let them show any document to my lord to show that the sale of the property is below the market price. It is much higher than the circle rate. Yes. My lord. Yes, my lord. I will, my lord, for that, my lord, I will declare in my document, my lord, for them to, first they have to pass a threshold of prima facie case. My lord, if they pass the threshold of prima facie case and balance of convenience, I will establish to my lord either a portion of that land I will mark out, or if I enter into any transaction. My lord, I am a businessman, I am a builder. I'm going to develop this land. So whatever that benefit, I will definitely, it's not going to happen in 6 months or 1 year or 2 years. Because they are not on any terms. My lord, my 64 crores is losing money every day. They are not depositing any money before the honorable court. And I'll put it this way, my lord, if I succeed in the case and my property is lying under litigation for 5 years or 10 years, the way it is, they will have no injury. Only I.
This between the second appellant and you will constitute 100% between the
Yes, yes.
So 60, according to the 61 and balance 39 would be this.
Yes. My lord, Monday or something, my lord. Please. At the earliest convenience of my lord. The earliest convenience. 28th of the earlier, because I'm saying here 29th, my lord. 29th, my lord. 29th. Or Monday, my lord. 10th or 29th. Very well, we'll take next one. No, that they have been taking time before this honorable court. The thing was, no, one date they submitted this, another date they submitted something else.
I've never taken time, I'll never take time. Let me make it abundant.
I have never said anything about learned senior counsel.
29th January, sir.
Or any earlier date, my lord. No, we'll take an earlier date. Any earlier date, my lord. No. I have 20th, my lord, 20th, my lord.
Sir, 22nd January, sir.
22nd.
Sir, 23rd Jan.
My lord, I should clarify, learned. My lords, senior advocate is actually not there. Mr. KG Raghavan is not there. So, no, we'll take it on 23rd. No, we'll take it on 23rd. No, 28th. 20th. Just see. Let it come.
No interim order in this case, my lord.
16th would be convenient, please. 66, please.
66, sir.
Sixteenth would be convenient, please.
16th not in station, by engage the senior, my lord. 16th is senior. Out of station.
Is your date?
25th, 26th.
26th.
20.
Sir, Saturday and Sunday.
That would be Saturday and Sunday.
27th or 29th.
20?
Sorry, my lord. Not seen the, sorry, not seen the calendar.
Sir, 27,
29th,
29.
29.
please. Sorry, my lord.
Unless may kindly be, it may be posted for final hearing, please. Very, very well, please. Shall I request it on the top of the list, please? Very well. Oblige.
Please.
Number 64, man. Steal from an interim order. It's a. Please. 71 for the appellant, my lords. My lords, in 71 and for the appellant, my lords, it's a short question of service law, my lords, where, my lords, we can begin, my lords. 64, my lords. It's a trademark infringement suit. I was granted an ex parte order, but the IA has been rejected on completely untenable grounds. I filed the appeal in August.
Also by you only.
The two IAs had been filed, both passing off an infringement.
I appear for the respondent.
An earliest possible date, because I have a registered trademark from 2005, which has been using from 1999. I operate a series of hospitals, including in Hyderabad. They started in 2014 in Bangalore. The Honorable Court says I came to Bangalore in 2016 and therefore rejects my IA, as though there is some geographical limitation. I,
17 to
Serial number 73, man.
Serial number 72, my lords.
From 1999, and I have a registered trademark from 2005.
I'm in Bangalore from 2013. 2013 in Bangalore, when they were not in Bangalore at all.
I was 8 years registered by then, and the law
There is a finding that they are not entitled to relief in equity also. So, my lord, there is no question. It's an equitable relief that they are asking for.
The law, my lords, is that he cannot claim to be a bona fide user once I have a registered trademark. Serial.
Yes.
Serial.
Next week.
72.
Not in January. Just give a date.
Serial number 72, my lords.
Our cases. Yes, my lords. Effectively, my lords, he was with another corporation, resigned there, came to the appellant corporation. Now, my lords, the only question is, my lords, our point is that he wasn't. So that is one question on whether there was proper permission, which is the test under the no, my lords. If there was none, my lords. Yes, my lords. Relief there, joined here. Then, my lords, the only question is, effectively, our pension rules do not provide for us to consider this prior service. There is no rule at all. My lords?
This service is pensionable.
My lords, the previous service, my lords, we don't have the rules to consider that.
The state government,
No, is it a pensionable?
it's a pensionable.
This is also pensionable.
This is
It
also
is,
pensionable.
so my lords, this service has been considered, that has been calculated. The only question will be whether the previous service can be, and my lords, our position will be that we have no rules to consider.
But the problem is that what is the service I have rendered in the government that has not been counted in the.
So
in the
this
service.
case is, their case is, we can't count the previous service because there is no rule.
There is a provision in it. There is a provision. I will show it.
Oh. Then who will discharge the liability for the previous service? Who will discharge the
That is
liability?
the government service. That is the provision is there. To
The state government?
Yes, state government. The provision is there.
Lord, serial number 68, my lord.
Serial number 67, 71.
My lords, a date could be given, we.
5/2, sir, 5th of February.
My lord, serial number 68.
Sir, 5th of February.
We have given you the earliest.
My lord, serial number 68, my lord.
Lord, serial number 68. Lords, could it be taken up on 17th or 16th or 17th? Lords, for this reason, my lords, the government has rejected the plan, my lords, of the society. My lords, subsequently, my lords, that has been allowed by the writ petition, the single judge, my lords. Now, lords, otherwise, commencing from 20th, my lords.
Serial number 70, my lords.
Yes,
What?
Please, ma'am.
60. 63. Serial number 63.
For the respondent.
Milords for the petitioner, milords.
63.
We are ready for the final arguments, milords. If it,
7.
Serial number 67.
14%. Sir, 64 is. 66 is also. 7.
14%
Yes, what remains in this?
Short question. Their pair was
And he said representation, what happened to that?
I'll verify, my lord.
lordship, I will explain.
I have some problem, that's why.
Ten three. Sir, March 10. March 10ನೇ ತಾರೀಕು.
Oblige, madam.
68.
68, my lord.
Let's appear for the respondent.
Respond.
Lord, the appeal
for my
itself
lord.
is not maintainable, my lord. Appeal itself is not maintainable.
No, it is
No,
preferred
the
by
PDM, my lord,
PD.
in fact, has passed the resolution. Now, my lord, the state has not filed any appeal. Now, BD has filed the appeal.
No, my lord, they don't have case, my lord. I can establish that.
That's only,
6-2.
Last week, my lord.
What's up?
I appear
69.
number 3, my lord. I appear for respondent number 3. Number 2.
Practice appointment.
69.
Please, my lord. Your lordship, the matter.
11-3. 70.
My lords, this matter came up yesterday, my lords. My lords was pleased to ask the government how the writ appeal is maintainable from the government. For the same reason, it was posted today, my lords.
Let's appear for the government, for the institute.
Mr. Malipatan. Yes,
Yes,
my
my
lords.
lords. There, an appeal is filed. Direction is both to the institute. It's an autonomous institute, but functioning under Department of Medical Education, which is an administrative institute. But ultimately, my lords, they might be absorbing them or special rules may be framed. Financial burden is of the state. Please, my lords. No, my lords, rules is not a problem, but the use of the words regularization and absorption in the order. In fact, my lords, our stand is that we had committed that special rules will be framed, providing for age relaxation and for grace for service weightage. So therefore, as a recruitment has to take place, then they will be provided that. But
this age relaxation and the service they have put in.
No, my lords, it was at the stage of framing of the rules. We had given an undertaking that rules have to be framed, and for that purpose, we are under consideration. That is what we had stated before the court. And my lords, what had happened was the use of the words regularization, absorption in the order has actually caused a confusion, because now they are under the contempt petition is under the premise that we are entitled to be regularized en bloc in terms of Uma Devi. My lords, it has to be read in that manner. That is the clarification we want from this honorable court. In fact, I went before the learned single judge in review petition and sought for this clarification. Single judge says, see, these are matters we cannot interpretation of the words. In fact, I brought out because regularization, absorption have specific connotation, my lords, in service law. Now, what happened? Please, my lords. Please, my lords. Please, I get it, my lords. But in so far as once we frame a special rule where I'm giving them service weightage as well as age relaxation, that means you have to participate in the recruitment process. So that's the argument, my lords. It's not automatic. So therefore, it is literally what they're seeking is an automatic, and the single judge's order literally gives them certain my lords, findings, my lords, in contrary to our undertaking.
If I may be permitted, my lords, in one of the notifications, we challenged the said notification and 1 or 2 posts were reserved for us.
How many were reserved? 67?
Total 1 or 2, my lords.
Lords, in fact, even in our affidavit also we had stated that till that finalization, there still continue. My lords, in fact, these are cases, my lords, where after Uma Devi, my lords, they entered into employment 2008 and 9. My lords, and before 10 years were over, litigation started whereby under interim orders they have continued. Still, be that as it may, we said since they're staff nurses. 2008 and 9 they joined service. 2006 they joined after Uma Devi.
The litigation
After
is only for
Devi,
10 years, my lords.
and 10 years minimum before. After Uma Devi also did not happen. Within 6 years, my lords, they were before this court. From that day, it is only on account of interim orders they are protected. But be that as it may, we said since they have during COVID time, my lords, they served. My lords, this order is coming in the way. If my lords, please, my lords. No, my lords, because if their allegation is that it would amount to contempt, even I have to regular, my lords, as per if the order of the learned single judge is read, it says that their entitlement to regularization is automatic, is not in dispute. The only thing is a manner, but it is not a question of regularization. So therefore, my lords, I would say that it is a matter to be heard. Please.
Sir, 10-3.
Maybe fixed at 2:30, my lords. If it's fixed at 2:30, my lords. My lords, it's been 10 years, my lords. They're all COVID warriors. Yes, my lords. We are not given the basic pay also, my lords. Please, my lords. Much obliged.
72. 72. Mahesh Chandra.
Lords, I appear for the appellant in 72 number, Lords. Lords, herein, my lords, the private lords have been not paid for salary for 10 months, my lords. My lords, 11-3 is a longer date, my lords. I would not be able to sustain, my lords. It's a service matter, my lords, wherein I have not been given posting as well as salary, my lords. Any date in this month, my lords.
Sir, 10-2, sir.
Grateful, my lords.
74 or 75.
73, my lord.
75 appearing for the respondent in this case, your lordship.
Written submission and synopsis.
25th March.
25th March.
Grateful, your lordship.
It's number 53 was passed over minutes. Item number 53, where my lord said, plus the NITK, the Surat, please. Let's may I, that's there, my lord, the contract which my lord friend was requested to look into whether it was produced or not, was not produced before the arbitrator. For the cost, the differential cost, my lords, it may be taken up at a shorter date, my lords, so that my lords have heard us, that's why. I understand, my lords. Any short date, my lords, that's my request. I'm grateful.
Sir, 53.
73 court officer.
Madam, sir, 70.
73 ನೋಡಿ.
Live ಅಲ್ಲಿ ಇದೆ live ಇದೆ ಒಂದು ನಿಮಿಷ. 73 12 sir.
Madam, 26 ಏನಾಯ್ತು ಮೇಡಮ್?
Sir, serial number?
76 ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್.
76. 27 3.
Madam, 75 ಏನಾಯ್ತು madam?
75 25 3.
Grateful. Thanks.
Court Officer, serial number 63.
63 63.
Much, thank you, thank you.
Madam, 23, serial number 23.
50.